Yes. Yes, tell me. The request of the learned counsel for the petition of matters adjourned to be listed of. One. Yes. Mr. Yes, on behalf of ask anybody else to come and say it. You are there?
For if it is.
Yes. Why it has become infrastructure?
That part I'll have to see. Yeah, we were just informed today morning that this ground will be taken.
Then we'll take up the matter. Then we'll see.
Settlement is there, Lord.
Because tomorrow, you see, you are known, you have not signed the Wakalatnama. If we pass an order tomorrow, Mr. Anybody, the client may either ask that person to be fit.
Number
60?
38.
38. Yes. Tell me.
We yet to file the actual record.
2018 matter. Sorry. We'll see on the matter. Why haven't you filed? $14. Yes. 2015 matter. Sorry. Next.
My ticket not bad.
2018 matter. Sorry.
Regarding the of the card. The in terms of the last order dated 7/9/22, this was communicated to them. I haven't received any instructions as yet.
There was a direction to file affidavit by the commissioner and secretary to the home department. That has not been done. Neither there is, in fact, you are not taking any or giving any importance to the orders passed by this court.
Well, the Lordship grants me a few days' time. I shall pursue it again.
Tomorrow?
Few days.
Tomorrow.
Uh,
You have to only get the information, what they have done. There is a direction. Have you communicated this direction?
I have, well, 7/9/22, the last order of this honorable court. That
Because we have already crossed 23. Now we are in 2024.
24. In terms of the last status report, of course, well, they had interrogated the other person who was trafficked along with this person who's missing. And they couldn't find any clues. The last report that I have on my hand.
When was
This was 29th July 22.
thereafter? On 7/9, this is the order.
Yes, but this
Then
is well,
The state CID was directed to do something.
Lordship grants me a day's time. Obliged.
This to matter tomorrow. I understand this matter is coming up for motion. Why is it?
Notice. Yes. Notice has been included here.
You are referring to the 16th July 2019.
No, my lord. This is 22. 29 July 22.
Hmm.
The status report.
Issue notice making it returnable. Returnable on 9th of January 2024. Miss S. Sharma appears on behalf of all the respondents. And accepts notice. She has further submitted. You have received you have received copies of the writ petition earlier.
No, my lord.
The counsel for the petition is directed to serve extra copies of the writ petition, but during the course of the day. To list the matter tomorrow on 9/1/2024, on which day Mrs. S. Sharma shall apprise this court as to what steps have been taken by the state CID pursuant to the order dated 7/9/2022 by this court.
Well, if I most humbly pray, can it be day after? Subject
Okay.
to the deeply
Issue
obliged.
notice making it returnable on 10/1/2020. Right. You give the copies today. Yes, what is this?
Okay.
These are all same matters.
My lord.
2/2/12.
But,
Huh? 2/10. Why are all these matters taken up together?
They have common issues, Lordship.
These are all writ petitions or contempt petitions?
Writ.
I see one item number 12, 11 and 12 are writ petitions. Or we are only
Lordship,
concerned
this
till
is
10,
only- yeah, two item.
3 to 10. Okay. Now what has happened out here? Different contempt applications. You want to impede somebody.
Right.
Whom?
Finance and taxation.
Huh?
Finance and taxation. Party response number 4.
Item number 2.
2, my lord.
This is not Rana construct.
No.
This is different.
Right.
Okay. Now you want to make finance and taxation
My lord.
as a party
As a part. Highest
to
report.
the,
Highest report.
oh, this one.
My lord.
Learned counsel for the applicant submits as in the application. The correct department has not been mentioned. You would like to withdraw the instant petition with the liberty to file again. Oh, that day
My
matter
lord,
came
I-
up before this
Yes,
court.
my lord.
Okay. Now you want to make the finance and taxation department.
My lord.
This is pertaining to the excise
My lord.
on the question of payment of excise duty
My lord.
and VAT.
My lord.
That 36. There's to do something with the 36, 2008,
Yes, yes,
Fine.
Lord.
8 or 18, 70, 16.
Rule,
That order of the
Yes.
governor.
the reassessment order.
Yeah. The instant application has been filed by the petitioner. To implead the Finance and Taxation Department of the Government of Assam as the respondent number 4 to the accompanying writ petition. I perused the said application as well as also the accompanying writ petition, and is of the opinion, and this court is of the opinion. This court have perused this thing. And this court is of the opinion that the presence of the Finance and Taxation Department of the Government of Assam is necessary for a proper adjudication of the accompanying writ petition. Accordingly, this court therefore impledes the Commissioner and Secretary to the Government of Assam, Finance and Taxation Department having his office at ground floor, F Block, Janata Bhavan, Dispur, Guwahati 781006 as the respondent number 4 to the accompanying writ petition. The petitioner is directed to file a amended memo of parties before the registry of this court by 10/1/2024, and the registry shall, on the basis of the instant order as well as the amended memo of parties so submitted, make necessary changes in the cause title of the writ petition and also upload the same in the CIS. I stands accordingly allowed.
All right.
Wait, don't.
Fine, fine.
There is nothing to run away. Where is the person concerned? Finance and taxation? Did you see anywhere in the vicinity, Mr.
Mr.
P.
Thor.
Gogoi
We hope.
or Mr. B. Chaudhary?
I-
They have not come?
I'm not sure, Lord.
Their names have been shown in the cause title, cause list.
They have received the copy.
Their names have been shown in the cause list. SP Finance, shown. Economic made reputation. Mr. Issue notice upon the newly impleaded respondent number 4. Nonetheless, appeared on behalf of the Finance and Taxation Department of the Government of Assam, although they have a standing counsel, although the state department has a standing counsel. The petitioner is given the liberty to serve an extra copy of the writ petition upon the standing counsel of the Finance and Taxation Department on or before 10/1/2024. To list the matter again on 12th of February 2024. The respondents the respondent number 4 shall file their affidavit on or before 7th of February 2024.
All right.
Yes,
Mother, these are the 30 applications filed saying for improvement of the present incumbent. the office of the chief engineer, PWD road, my lord. The matter relates to my lord, the non-payment of the forest royalty, my lord. That amount they have deducted from our bills, my lord. That's the direct.
Oh, that matter.
Yes.
In view of Justice Chaudhary's judgment.
Our claim was to refund the amount, my lord, and that exercise has not been done. My lord. Therefore, we have filed this complaint application.
Tell me one thing.
Right.
The judgment of Justice Chaudhary does not show how much amount is to be paid.
My lord, that has to be verified by them, my lord.
So under such circumstances, what is the amount they are going to pay?
My lord,
Are you only on the question that they are not verifying?
yes, my
Or are you on the
Sir.
question that they are not paying? Because if you are not, if you are in the question of not paying, then it would be a case of a fresh petition. Because there has to be a quantification of a particular amount.
Our claim was to refund the amount.
Understood.
Yes.
I have seen the, I remember the judgment of Justice Chaudhary out there where he has, I think in the penultimate of paragraph out there, has
Yes.
categorically mentioned that kindly the department shall refund the amount. Now, if they don't refund the amount, wouldn't it be a cause of action? Because as of now, the court did not decide how much amount or what was the amount at all to be payable.
That is not there.
Because at the end of the day, you will be in difficulty. How do you today, this court can at best pass an order to make the verification. That's all. The question of contempt does not arise unless you say that in view of this order which has been passed, we have made the application asking for this particular amount of money which have not been paid.
This petition, my lord.
If you see, kindly see the IA.
Right.
Because you will be in more difficulty. Kindly see the IA, page 8, annexure A, compliance. With reference to the letter, we have the honor to inform you that the order has been passed in so and so. However, due to non-compliance of the order dated has not been instituted, the letter is issued without prejudice and without derogating from our earlier communication and sent to you as an integral part of the entire communication with you on the subject matter. We reserve a right to the right and nothing shall be deemed to as waiver as well. This is for your favor. Has been written on 3/6/2023. Then how will they know what is the amount? Because the order, if you see the judgment in the main order, if you see, it was a common order by which various writ petitions were disposed of.
In this contempt petition, this was the order passed by my lord Mr. Justice T.R. Mike. If lordship takes a contempt petition,
No, let us see the order by which you are asking for the money.
that will lordship will find it page 8 of my contempt petition. Page 85
8.
of 2018.
The contention of the department is that some deduction was permissible under so and so and so and Mr. Chaudhary, the learned counsel submits that the case of his client is covered by the aforesaid to the Mr. S.R. Borwar and so and so could be covered by the aforesaid. Consequently, the impugn order rejecting the claim of the petitioner for refund of the forest royalty stands set aside. Department will now take steps for refunding the amount of forest royalty deducted from the petitioner. How much? Have you asked for?
My lord,
At page 11, you have asked for this amount.
this is the amount, my lord. Paid for refund of 29,52,000.
Understood. Wouldn't it be a separate cause of action?
Now, my lord.
That this amount is the amount which I am entitled to pay in spite of the order passed by this court.
I paid in the writ petition, my pay was to pay for, I paid for refund of this amount, my lord.
This amount.
I made an application to them, kindly return me this amount. They rejected my claim, my lord. That is
Hmm.
why we filed this writ petition.
Hmm.
Challenging the rejection order. Thereafter, this order was passed.
What is the affidavit file?
But,
There is some affidavit file, na? Who is the respondent number 2?
he is the earlier chief engineer. Diptyojyoti Sahoria. We heard from sir.
Now 1 is no longer there.
One and two.
1 and 2.
Yes, 1, 2. And my daughter, respondent number 3. I think he is also the research officer.
So these applications are filed in the same writ petition or same contempt or
Same.
different? All are different contempt.
All are different concepts.
Where you are asking for implement of
Different department, my lord, in the instant contempt petition, I am praying for improvement of Sri Jayanta Kumar Goswami,
as a chief engineer.
chief engineer, road, border.
And the other ones?
In item number 4, my lord. Sri Sandeep Shyam, he is the chief engineer, public work, road department. In item number 4. Item number 5 is again Sandeep Shyam.
Who is appearing for these respondents? The earlier respondents? Their names have not been shown.
Earlier for respondent number 2, Sri Diganta Kumar Roy, he filed this affidavit, my lord. Both the affidavits were filed by him.
The instant application has been filed by the petitioner, seeking the permission of this court, seeking the leave of this court to implead Sri Jayanta Kumar Goswami, Chief Engineer PWD Border Roads, Assam. Why you are asking 3? If this is, we already have 3 respondents. At the respondent number 4,
4.
in the accompanying contempt application, on the ground that Sri Jayanta Kumar Goswami is the present Chief Engineer, PWD Border Roads, and who was also duly intimated about the order for compliance with the order dated 31/8/2018, passed in WPC number 2456/2017. This court, upon taking note of the contents of the instant application as well as the accompanying contempt application, is of the opinion that Sri Jayanta Kumar Goswami, the present Chief Engineer PWD Border Roads Assam, is required to be included as the respondent number 4 to the instant contempt application, to the accompanying contempt application. Accordingly, the said Sri Jayanta Kumar Goswami, Chief Engineer PWD Border Roads Assam, is arrayed as the respondent number 4 to the accompanying contempt case number 385/2018. The petitioners has submit a fresh memo of parties before the registry of this court. And on the basis of the fresh memo of parties, along with the on the basis of the said fresh memo of parties and the instant order, the registry shall make necessary changes in the cause title of the accompanying contempt application and also upload the same in the CIS. It shall file the fresh memo of parties on 10/1/2024. এই ওপৰত সেইটোতে লিখি দিব shall file it on এইটো এইটো হৈ গ'ল আৰু I accordingly stands allowed আৰু এইখনত মেইন খনত এপ্লিকেশন খনত লিখি দিব heard Mr. So and so, the learned counsel appearing on behalf of the petitioner. None has appeared on behalf of the respondents on call. Issue notice upon the respondent number 4 by way of registered as well as usual by 10/1/2024. List the matter again on 12/2/2024. Hey, Baki Gita will be same. Same, no?
Respondent name with.
Now all will be same. খালি এই এটা চাই ল'ব দেই, তিনটা যদি আছে 4 নম্বৰ হ'ব।
I declare right.
All eyes allowed. Top 12. Why?
My senior is another. Under 1 week time, maybe grandfather will file our objection.
Four to 12, who are these?
NGO, my lord.
You want to be a party in the where? In the writ petition? Yes, yes. Tell me. Why? What?
I don't have the petition right.
Very good. We dismiss it on the ground that you are not ready. You are appearing before the court without a petition. We dismiss it on the ground that you are not ready. Just tell me, what is the case about, writ petition about, mister?
My lord, we have been served and eviction notice, my lord. My lord,
Huh?
eviction notice in the writ petition, my lord. Page,
Arya Vidyapit College.
Lord,
You have been served with an eviction notice. By
by the government authorities, my lord.
them.
Okay.
Why?
My lord, they are alleging that we are encroaching DAG number 381, my lord. But we have never encroached any DAG number. Any DAG
And
number.
who are they?
They are, my lord, NGO, my lord. So they have filed a PIL for establishment of a children's park over that state DAG number 381, my lord.
Hmm.
That 381 DAG number is a natural stream, my lord. My lord, no park can be made over a natural stream. So they are now alleging that we are encroaching DAG number, my lord, 31 page number that notice.
Just 1 minute. This is why you have enclosed the PIL. Why? They are the parties in the PIL.
Their part.
They are the parties in the PIL.
They have filed a PL. We are no.
Understood. You have enclosed this document.
Look.
That order passed by the in the PIL. Why?
Look,
In your petition.
look,
Why?
look, regarding the establishment of children's park, but that area is not. We have never encroached.
Let us see your interim notice.
Page, annexer 4, page 31.
Regarding encroachment of the common dark number so and so with reference to the I to inform you that you are occupying a portion of land for the cost. You are hereby directed to take immediately on the but you can try to be carried. Then the case projected by them in a nutshell is that there is a plot of land measuring more than 5 acres covered by dark number 70, 381, 382 covered by point. In the case of the state land has been reserved by the government for demand. However, though such a decision was taken to keep the plot of land reserved, there are no further work in Yes. Are you in dark number 381?
No,
Are you in any way in government dark?
182
You are in government dark.
from 1958. They are hostel.
So why are you concerned with 381?
London eviction notice has been,
But that is only for 381. You are saying about 152,
182.
182. Yes, madam.
They are not encroaching DAG number 381. Should not be worried about that.
Why are you worried? Why should you be worried if you are not in dock number 381?
But my lord, my lord, no physical survey has been done, my lord.
We'll pass the direction. The revenue officials shall make a certain as to whether you are there in dock number 381 or 182. If it is the case of 381, then they shall proceed as per the notice.
My lord, can it be after some time, my lord?
No, nothing doing. Matter is over.
The
What is
survey and demarcation may be.
Huh?
Survey and demarcation may be conducted and
So you are concerned, you are saying you are in 182, remain in 182.
My lord, can we after some time, my lord, my senior, my lord, after some time.
Who?
My senior, my
Who is your senior?
TKT, my
Yes, ask him to come. These application will be made instructions.
after some time. Highly obliged.
May be the-
Yes.
But here, its application is in filed for treatment of the Chief Executive Officer, Golaghat Municipal Board, as a party response.
Why?
Because in this case, the main direction was the Golaghat Municipal Board in the earlier round of retreat. And thereafter, they have shifted the burden to us. Now, we made chairman and the Golaghat Municipal Board as party response. But they have not appeared till date. And notice has been served, duly served upon them. Therefore, in order to dispose of the restriction in an effective manner, the Chief Executive Officer of the Golaghat Municipal Board be a party response.
No,
Because the
should not
direction-
be issued to set aside and quash the order dated 27/1/2000 passed by the chairman Golaghat Iman with a further direction to ER to provide alternative suitable accommodation to the petitioner in the visible market in terms with the order dated so and so and so and so and all causes. Now this is your prayer.
Yes.
Now whom do you want to make?
The Chief Executive Officer, Golaghat Municipal Board.
They are already there.
No, his chairman was there.
Who has passed the order?
Lordship, this order was passed by the chairman municipal board at that point of time.
Why do you want the chief executive officer?
Because now, at this point, because the chairman has not responded. And the direction
Not
in the
responded
repetition-
very well. We set aside that order. Why do you need unnecessary people out there?
Because Lordship, in the page 46, the order of the dishonorable court was, there was a specific direction to the Golaghat Municipal Board. That is at para 2. That Golaghat Municipal Board shall allow him to set up the stop at the appropriate place, taking into account of the earlier order passed by dishonorable court as referred.
Mr. Das, this matter which I've heard on the central jail matter, the land, I will again, I have some queries. While dictating the judgment, there were certain things which has come into light. I will have it on Thursday next as to be spoken to.
Yes, no problem.
I will go, I'll ask you specifically because I would have had it tomorrow, but I'm told that Mr. Rajiv Gorpujari is in bereavement, so it would not be proper, so I'll have it on Thursday. The issue which I will be asking you
that's
is on the question of facts, on the facts, because the facts which was there was a bit disturbing when I was going through the file. Yes, the law point is different, but the facts was very disturbing. The more particularly as regards the power of attorneys which have been issued.
Right.
The power of attorneys have been issued in the name of one Bhuya Projects.
Correct.
And the director was one Mr. Ripun Bhuya. If you see the power of attorneys have been given for the purpose of selling also, which is absolutely contrary to paragraph number 13 of the affidavit in reply filed by them, as well as on 28/2/2012 or 12, I think, you have submitted a representation, and in paragraph 3AC, you have made a submission which is completely contrary to the power of attorneys. Now, these power of attorneys, were brought to the notice of this court by way of filing of an affidavit, you say that this particular power of attorneys we have revoked it. Now, you know that a registered power of attorney cannot be revoked unless it is being done by another registered instrument. So this revocation has no value as of now. Now, you have now also enclosed the agreements. Those agreements which you had with Bhuya projects. Now, another thing, you have written that is your reply to the affidavit filed on 9th of February 2018. Out there, you have replied out there stating that you have informed the register, the sub-register, about the revocation. Now, the fact which you have mentioned out there about the revocation, you have informed. Interestingly, in that revocation, you have mentioned that we have asked them to make the construction, they are not doing so. And the construction permission which have been sought for is again for residential as well as for commercial, nothing to do with modernized factory. And further to that, in the power of attorney, the power has been given out there for the purpose of selling the modernized factory. So these are the various aspects of the matter which one. And apart from that, the biggest thing is now the secretary under whom the case was filed, Paresh Chandra Hadaloi, he's no longer there. He has been removed. There's no problem. The power of attorney to whom it was issued, one Mr. Ripun Bhuyan, now files an application which was allowed by this court and made him, now he is representing the society. So these are the facts which I'd like to ask you on.
I will ask you. Thursday or not?
Thursday.
Thursday.
Item 1.
Right.
To be spoken to, it will.
Last occasion when the matter was dictated, the court has appointed the Golaghat chief executive officer, Golaghat municipal court, the necessary part. But kindly peruse the order dated 13/12/2023. I'm reading the third paragraph. It transfers that the grievance of the petitioner can be redressed in effective only in presence of the respondent Golaghat Municipal Board. Mr. Tamali, the counsel for the petitioner, has submitted that he will make the application.
Yes, Mr. Sharma, you are paying for whom?
Chairman has made a party. Generally, executive officer is confirmed when chairman is no elected chairman. If there is an elected chairman, there is no executive officer. So when the chairman itself is part the order, and he has made a party, and he has received notice, and but does not appear, your lordship has passed order to the FIR. So there is no point for making the executive officer as the party member.
Now, who does the municipal board
Yes.
have a chairman?
Yes, chairman, elected chairman. When there is no elected body,
Then only the
executive
chief
officer-
executive officer will
then
come in.
executive officer confirm my job. So whether it is the elected chairman or not, that has to be a certain task. If there is the elected chairman, he has already received notice, and there is no executive officer. my
Now,
lord.
you are paying for whom? Golaghat
I
Municipal
am
Board.
paying for respond number 3. Practice my lord a bit different because
Who is the respond number 3?
my lord Bapi Pal, he was the occupying the land by the of the by the municipality. And earlier the petitioner has filed a writ petition, my lord. In that writ petition, your lordship has passed the order directing municipality to keep possession of the land, my lord, which is in possession of the present petitioner, my lord. So after receiving notice from the municipality, he directly come and file this petition, my lord. But the notice was issued to him as per judgment passed in earlier case, my lord, filed by him, my lord. So the executive officer has, the chairman has issued notice to him that you vacate that plot of land, I will give you another plot of land. Receiving that notice, he has passed the order, filed this case, challenging it, my lord.
Mr. Burua, this means why problem arises because why haven't you made the state of Assam a party?
Here,
You should have made the municipal administration a party. The urban, what you call, the municipal and urban body the
Yes.
department. You should have made that. Because if we have made that, then we can catch all of them through them. The problem arises with these municipal boards. If they don't represent, the matter ends. And if they are not representing, the order will be passed. Will you? As if there is nothing to say by them. But is there any executive officer now?
Yes. there is
How do you know?
I have been instructed that there is an executive officer and the last book is not, he appeared for the chief executive.
Who?
I don't know his name.
Earlier, it is filed by team was 5409, 2008. In that case, he, there was a pass order directing principal to hand over the possession of the land in his possession to the present restaurant number 3. Instead of that, he will be given another plot of land. So the principal has issued notice as per direction of your daughter to hand over the possession. If you didn't take notice, he has filed case.
But there was part of the order. In the earlier decision, there are two parts. One is to vacate and another is
No,
to provide.
all
an
are
alternative.
understood, Mr. Counselor. But the problem is, how can I make a fictitious body a party unless there is a chief executive officer?
Certain is after time. I have a
Yes, Mr. Borua. Can you find out whether the what is this, Gwalpara? Gulaghat Municipal Board, does it have a chairman or is it being taken over by a chief executive officer?
I will find it out.
Okay, we'll have it at 2.
Yes.
Just find it out. If it is there, now it has been taken over by a chief executive officer, then we'll make him. Otherwise, the court will proceed on the basis thereof. If I'm not wrong, as per the Assam Municipal Act 1956, the chief executive officer only is an appointee of the government.
Government, he's a representative of. the-
He's a representative of the government, but he is not otherwise. He has nothing to do unless the municipal administration is being taken over by the government.
Exactly.
And the problem arises that the municipal administration, if it is taken over by the government has to be made a party.
plot. I have the instruction that there is an executive, not chief executive officer, but executive officer. Now Bhargav Kalita is serving as the executive officer of Gulaghat.
So they don't have a board.
Regarding the
Just
board,
find out.
I will
We'll have it at 2.
find-
As to whether the Gwalpara Municipal Board, the Gulaghat Municipal Board
as a-
has been taken over by the government. Then only it will be. Otherwise, it will be represented by the chairman.
Taken up today or
Today, 2 o'clock. Right. Mr. Day. Come on. Yes, tell me. You are, huh?
Vidyapit College. We have our hostel building, dark hostel.
Do you have it in 381? Are you having your the building at 381?
No.
182?
My lord, at this moment, my lord, I cannot exactly say that.
No. What is your case? You don't know your repetition.
My case is that we have to construct our building on the allotted day.
No. You say that you are in dark number. Which dark number?
182.
182.
My lord.
So the petitioner states that on the southern boundary adjacent to the natural stream of dark number 381, there exists plots of land measuring of dark number 182, 380, 378. It may be mentioned that dark number 182, 378 area is surrounded by dark number. That the whole land, the petition says that the whole dark number area is with an area of 10 acres and has been allotted to the petitioner college by the government. 182 has been allotted to the government.
182.
This plot of land is covered by dark number, patta number 5 of dark number Iman and has been mutated in the name of the Iman. This plot of land is in the western side. So, we can dispose it off. Saying that they will make the required demarcation and find out if you are in dark number area, 182, then this notice has no meaning. And if it is in dark number 381, you are there, you are to be evicted.
So far on the demarcation.
So that is the direction this court is going to pass.
Demarcation, I cannot object, my lord, I cannot oppose. My lord, my grievance is that I should be given an opportunity of hearing against that demarcation.
What hearing?
My lord.
They will make the demarcation. Find out as to whether you are there in dark number 381 or to dark number 182. If you are in dark number 182, they shall not.
In case,
And in your presence.
in case they make wrong demarcation,
they make wrong demarcation, then what do I do?
We are the layman, my lord, we do not know. my
No,
lord.
no, you have to be. You are, they have the assistance of Mr. KK Dey. So he will do it. Yes, where is the revenue council?
Only thing, my lord, we should be given an opportunity of hearing.
Mr.
Against the market.
Mr. Bolwa, you are appearing for the DC?
Yes.
Kamrup district, the circle officer?
Yes.
So I passed I dispose of the petition out there because if it is in dark number, they say that they have been allotted a plot of land of 10 bighas or something in dark number 182 or patta number 5. So if they are there, you cannot disturb them in their land. But if it is they are in occupation of dark number 381, then you can take such course of action as is available under law. Okay. The instant writ petition has been filed challenging the notice bearing number GC.49/2015/2929 dated 10/11/2022 issued by the respondent number 3 circle, that is the circle officer, Guwahati Revenue Circle, Kamrup Metro. Full stop. The facts as would be discerned from the writ petition is that the petitioner herein is a government-aided college established in the year 1958. Full stop. It has been mentioned that the petitioner college building is standing over a plot of land measuring 4.2 bighas covered by dark number 128. Where is the patta? No patta.
Customer, I have annexed the Jamabandy.
No, what you are saying. No, this Jamabandi has a patta. Patta number 5, yes, you see. No, not that. Kindly come to paragraph 2 of your writ petition.
Okay. My lord, the college is on a different plot of land.
So you are not
My
on
lord,
that.
my lord, I am not on that.
But that is again, you have put it as dark number 128.
128 is the college building and our hostel building, playground, etc. is 182.
The facts it is a college like.
My lord, I have
It
my
is-
submission, lordship.
You take your seat. The petitioner's case is that the petitioner college stands over a plot of land measuring 4.2 bighas covered by dark number 128 of Moza Sohor Ulubari Part 3, situated on the western side of AK Azad Road, Gopinath Nagar, Guwahati 781016. It has been claimed that the said plot of land covered by dark number 128 was allotted by the government of Assam for establishment of the petitioner college. It is, however, relevant to mention that no such documents have been enclosed to the writ petition, taking into account that the said dark number that there is no dispute as regards the establishment of the petitioner college. It is the further case of the petitioner that dark number 182, which has an area of 10 bighas, 2 kathas, 10.51 lecha, was allotted to the petitioner college by the government of Assam And upon allotment, the said DAG number became upon allotment and settlement was granted by issuance of periodic patta number 5 to the petitioner college. It is the further case of the petitioner that the petitioner college had thereupon established its hostel on the said plot of land covered by patta number 5, covered by DAG number 182 of patta number 5. It is also the specific case of the petitioner that the petitioner is not in occupation of government DAG number 381. Of Sohor Ulubari Part 3 under Ulubari Moja. However, the petitioner was issued a notice by the Circle Officer Guwahati Revenue Circle on 10/11/2022, alleging that the petitioner college had encroached the government DAG number 381 of Sohor Ulubari Part 3 under Ulubari Moja. It is under such circumstances that the petitioner had approached this court, challenging the said notice. This court have also taken note of that a society in the name and style of Assam Society of Center of Excellence, which is a registered NGO, along with 11 others, had filed a public interest litigation before the division bench of this court, which was registered and numbered as PIL number 70/2018. From a perusal of the said order dated 26/8/2019, passed in PIL number 70/2018, it reveals that the said society had projected that a plot of land measuring more than 5 bighas, covered by DAG number 370, 381, and 382, situated Gopinath Nagar, Sohor Ulubari, Moja Ulubari, Part 3, in the district of Kamrup Metro, Assam, was reserved by the government of Assam for a children park by the communication dated 3/6/1999. It is, though such a decision was duly taken by the government, but taken by the government for the purpose of creating a children park, but no steps was taken which had led to encroachment upon the said plot of land. And it is under such circumstances that the public interest litigation was filed. In the said proceedings, the respondent number 2 therein had filed an affidavit in opposition, wherein it has been mentioned that there were certain encroachment, including an encroachment being made by Arya Vidyapit Higher Secondary and Bahumukhia Vidyalaya by erecting pakka pillar with iron pipe nearby the road. It is seen that the division bench of this court in its order dated 26/8/2019 in PIL number 70/2018 had duly taken note of the stand taken by the state government that the encroachment would be removed, had observed that keeping the land unutilized may create further problems of encroachment, for which there was a direction for establishment of a children park within 6 months from that date of the said order. Therefore, from the above judgment order passed by the division bench dated 26/8/2019, it is clear that amongst the various other DAGs, DAG number 381 is one of such DAG wherein the government had reserved the said land for the purpose of construction of a children's park, and there was a direction for the purpose of construction of a children's park. Therefore, any eviction drive so carried out in respect to DAG number 381 cannot be interfered with, more so in view of the order dated 26/8/2019 passed by the division bench in PIL number 70/2018. Be that as it may, this court have also taken due note of the submission of Mr. K.K. Day, the learned counsel appearing on behalf of the petitioner, that the petitioner college is not in occupation of DAG number 318. However, the respondent authorities have illegally issued the said impugned notice. It is the opinion of this court that the said dispute can be well settled by issuing an appropriate direction to the respondent authorities. Accordingly, this court therefore directs the respondent authorities to carry out the demarcation in respect of DAG number 381 of Sohor Ulubari, Moza Ulubari Part 3. And after carrying out such demarcation, if it is found that and after carrying out the demarcation, if it is found that anybody is in occupation of the said land, appropriate steps may be carried out over the said land in accordance with law. This court further observe that the respondent authority shall take due care that in the name of DAG number, government DAG number, in the name of taking appropriate steps for eviction from government DAG number 381 of Sohor Ulubari Part 3 under Ulubari Moja, the respondent authority shall not interfere with the possession of the petitioner in respect of DAG number 182 of Pata number 5. With the above observation and directions, the instant petition stands disposed of. Interim orders, if any, stands vacated. The said exercise be carried out within a period of how much? 6 months, 6 weeks?
It's here.
6 weeks from the date, from today.
But time for response.
You could give your name.
My lord,
I Didiok. In view of the disposal of the said writ petition, nothing survives in the instant application for
My
which the same stands clear.
my lord, I am for the Assam society.
Not necessary. I've already disposed it of. Why is it necessary to you? Your only anxiety is because of this stay, nothing is happening.
Ah.
So the interim order, I have asked them to
Okay.
go and make the
Okay.
demarcation in respect of
Okay.
381 and to proceed.
Yes.
My lord, in PIL, we were not parties, my lord.
No,
And the
But then also you are not
Chil-
there.
children-
No, but
children
Mr.
party-
Day,
children party is only sealed, my lord. Intention is otherwise. They are
whatever may be, 381 is not your task. Ate.
I'm obliged.
Yes, you wanted to withdraw. Somebody wanted to withdraw. Yes, you. You were there, one of the first person.
Lord, we have got nothing from our client, not this, because the matter is settled outside the
Has been settled outside the court. Your name?
court.
Naam to Lulupati. Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. And you also confirm it has been settled out of the court?
Actually, my lord, the entire matter has come up to 2015, and thereafter even the
Okay.
APS doesn't have a copy.
Submits that she has instructions to withdraw the instant writ petition, taking into account that the matter has become instructed. Accordingly, the writ petition stands closed on withdrawal.
If, in all probabilities, the petitioner doesn't have a case because they have been claiming that there has been illegal trespass and entry into his plot of land for construction of JICA assisted project. But from the report that we have received and the circle officer's report, it has come out very clear that the petitioner is in illegal occupation of the particular dark, which is claimed to be his own, which actually belongs to the Asoklanta Devalaya. And some part of it, this dark has been in illegal possession of his, and he's an encroacher, and that is clear. So maybe and that apart, he has been claiming that he is cultivating tali and cultivation, but that is not possible because of the terrain.
What type of sale deed is this? Huh? The sale deed doesn't have any dark. It has many things, but why it is not? None appears on behalf of the petitioner on call. This court have also perused the writ petition. And from the writ petition, there is no document shows, prima facie, which shows that the petitioner is the owner of a plot of land measuring 1 bigha 2 katta, covered by Lakiras Patta number 1 of dark number 338 old oblique 37357 new of village North Guwahati under Moza Sila Sinduri Gopa in the district of Kamrup rural Assam. The sale deed so enclosed, the deed of sale so enclosed as Annexure 1 is not legible, and the translated copy therein also does not mention any dark numbers or patta numbers. So under such circumstances, in the opinion of this court, nothing there is that in the opinion of this court, as there is no material showing the petitioner's ownership of any plot of land, the question of passing any interim order for protection of the petitioner, possession over the land or for compensation does not arise. Accordingly, the instant writ petition stands devoid of merits, it stands dismissed, being devoid of any merits. Mr. There's some additional affidavit file, na? None appears on behalf of the petitioner on call. I've also heard Mr. S. Pulver, the learned counsel, appearing on behalf of the state respondents. The petitioner herein have filed the instant writ petition, taking appropriate direction upon the respondent authority not to dispossess the petitioner from a plot of land measuring 1 bigha 2 katha covered by Lathira's patta number 1, dark number 338, bracket old, oblique 357, bracket new, of village North Guwahati under Moda Sila Sinduri Bhupa in the district of Kamrup, rural Assam. And further, for an appropriate direction upon the respondent to make suitable compensation to the petitioner in case the petitioner is dispossessed from the said land. The record reveals that the petitioner had enclosed the deed of sale as Annexure 1. However, the said deed of sale, 1 to the writ petition. However, the said deed of sale does not mention deed of the photocopy of the said deed of sale is not legible, and the translated copy does not bear any tag number or patta numbers. Be that as it may, there is an additional affidavit so filed, wherein a better copy of the deed of sale dated 1905 to 1975 have been enclosed as Annexure A. From a perusal of the said deed of sale, it reveals that the land belongs to North Guwahati, Oxfordlanto, Devaloy. And under such circumstances, it is not known on what basis the said deed of sale was made by certain persons in favor of the petitioner. This court have also duly taken note of the affidavit in opposition filed by the respondent number 5, wherein it has been mentioned categorically The land in question was a Debotto land belonging to Sri Sri Ashwaklanta Devaloi Trust and Sri Govinda Chandra Sharma in the capacity of the Doloi oblique the president, and Sri Bipul Sharma, the government nominee of the Ashwaklanta Devaloi Trust, in its meeting with the Guwahati Metropolitan Development Authority, had adopted a resolution dated 12/8/2010 and agreed to hand over the land measuring 2.78 hectares, bracket 20.08 bighas, bracket close, covered by dark number 357 of village Uttar Guwahati, town Moja Sila Sinduri Ghopa in the district of Kamrup rural to GMDA for the purpose of the water supply project under the assistance of the Japan International Cooperation Agency, and a special power of attorney dated 11/8/2014 was executed to authorize the project director of JICA, assisted GWSP, to take over the land from the state trust. It was further mentioned that the petitioner had no right over the said land, as the Debuttal land could not have been acquired and sold by late Mohat Ram Soikia and his legal heirs. Taking into account the above, this court is of the considered opinion that the petitioner have not been able to make out any case for the purpose of interference for issuance of a writ in the present proceedings. Accordingly, the writ petition stands devoid of merits, for which the same stands dismissed. Because the interim order, if any, stands vacated.
For a third, against the Milord order of the revenue board, the writ petition has also been filed. That is Milord W56/412 of 2023. Respect to the same statement may be favor of the assessment period.
Well, asking for setting aside of a settlement.
Exactly. Now, look, there are two aspects. Firstly, Milord, because the inaction of the police authority. In fact, the antisocial elements, Milord, they took part into my property. And in fact, Milord, number of affairs were lost. No action was taken. In fact, Milord, they acted on the affairs lost by the antisocial. And in fact, I was required to take anticipated bail. Then getting cases are pending against me. Whereas, Milord, we file number of affairs, Milord. None of them, Milord, follow the affidavit. They say that this is a registered, that has not been charged as yet. In fact, Milord, against the Milord order of settlement, we have gone to the revenue board. In fact, the revenue board, Milord, because of the problem, there was a delay. So that was rejected. In fact, Milord, against the dismissal of the revenue board appeal, Milord, that is the revision that WPC6412 of the 3.
Very good.
Milord, that is it was lastly listed at 2011-23. Presently pending in this court.
Now, why are you asking for setting aside the settlement here
Because, Milord, here, what has happened, Milord?
when you have already challenged it before the
No,
Court of Revenue?
That is why, Milord. In fact, that was challenged. The appeal before the revenue board was dismissed. Against that, the writ petition has been filed before the court.
Understood. So that is another aspect.
Aspect.
Then why are you again challenging the
So
settlement
this
here?
was, Milord, this was long back, Milord. What had happened, Milord? Because of on the basis of those letters, Milord, the settlement, Milord, the police authorities were not acting. That is why, Milord, in fact, from 75 onwards, I am in regular possession of the land. Physical both possession of the regular.
But you don't have a settlement in your name.
Understand? Now that is what the certificate, the settlement was obtained on the basis of false documents because they were never in possession of the land. The records which which are annexed to the writ petition from 75 onward, I'm in continuous possession of the land. And second thing, your lordship says, from
But
the
you have
step,
already challenged the settlement in some other proceeding.
that was
Why,
subsequent.
why should this court interfere with this?
So that is my lord. Only thing, lord, can I pray, my lord, since my lord, the matters are similar, my lord. With this petition may be checked with 641.
No, nothing doing. How do you have the same cause of action in respect to two petitions? Here you are challenging the settlement also,
Settlement law.
wherein you have already approached the Board of Revenue challenging the settlement, which was dismissed, and against that a writ petition is pending. So how can you do both?
So that was that is true, my lord. In fact, the settlement was challenged. That the
Nothing
the
remains.
agreements will support the other.
And you are agree about the you have the Land Grabbing Act.
In fact, that is what, my lord. That is my the first part is the lord. Number of efforts were lost. None of my cases, although my cases were registered subsequently, but
Eh?
it was
You can very well file an application before the tribunal.
no, my lord. In fact, they were raised. Those cases were registered. If your lordship kindly come to the affidavit filed by the respondent number, my lord, I'll just take it to the respondent. Just my lord, filed by the respondent number 7. Lordship kindly come to paragraph 4 of the affidavit.
Yes.
Second part will however, the further states that a non-FIR proceeding under 107 was submitted proceeds to put it against the respondent.
107 proceedings is different.
I understand, my lord. Now, my affairs, my lord, this were registered at 107 proceeding. Lordship will kindly come to the next page again. From the top, my lord. Proceeds of PSK 726 so was registered and investigated into. Now, thereafter, my lord, it was never referred to the court. In fact, my lord, now I am a victim there.
Understood. The police did not do anything. Go there. Does it stop you from filing a case before the tribunal on your own?
Definitely, my lord, but because of the fantasy of this, my lord, I'm not aware will have to happen to this particular affair.
What?
Whether, my lord, there's no final report as on
Oh, how does it matter? You have a recourse out there. But first, you have already challenged the settlement in a proceeding before the Board of Revenue, which was dismissed. The matter is pending before the High Court. That's another aspect. The second is, as regards any land grabbing, if it is done out there, you file a land grabbing case before the court. Then how does it have anything to do out here?
the lordship, we have praised that one thing. Lordship, maybe give me the liberty to approach the tribunal, my lord, for because it's a case of 2015.
Are you still having a threat?
That, my lord, but my property is gone. And the property is gone, my lord. There was a, my lord, fabrication unit there involving crores of rupees, and their property has been, my lord, seized.
They've taken.
Yes, yes, my lord. They are, in fact, they are in possession. I have never been allowed to go inside. In fact, they have started construction, my lord. My lord, even, my lord, they were threatened at gunpoint. Those things were there. I was personally present. In fact, ultimately,
You see, this is the proceedings on the basis
Understand.
of affidavit. How will the court decide?
so in fact, my lord, there
On
is-
one hand, you are saying this, whereas the government is saying something else, that all the threats which have been given by you are wrong.
no, my lord, nothing is being, my lord. But the affair says, my lord, the affidavit says, my lord, it is being investigated, not beyond.
Hey, they say that nothing could be found out.
No, my lord. If your lordship sees,
Paragraph 9 of the affidavit filed by respondent said,
this railway service, the respondent number so and so submitted an affair so and so. Running in this 20 and was data to the banking. Now, lord, what that is what means. They lodge affairs. The anti-socialists, they lodge affairs, my lord. Those are taken into account, my lord. My affairs have been thrown into the dustbin.
so then 156.3. Have some recourse. But how is the court going to decide after
That is
226?
why, my lordship sees Just my lord, liberty may be given to me to file appropriate action. That can be done.
Mr. R.D. Dillon, counsel appearing on behalf of the submit that taking into submits that for the, that against the settlement order granted in favor of the respondent number 9 and 10.
9 and
9 and 10.
9.
The petitioner had already challenged the state settlement order before the Assam Board of Revenue, which was, however, dismissed, for which the petitioner had already filed a writ petition being deputy number
6412 of 23.
20,
23. 6412 of 23.
23. The said writ petition is pending. The learned counsel further submitted that as regards the allegations so made by the petitioner, and as regards the various threats received, the petitioner have the learned counsel further submits that as regards the other allegations which have been mentioned in the writ petition, same would require entering into disputed questions of facts which can only be adjudicated in a forum where facts can be adjudicated. He therefore submits that he may be permitted to withdraw the instant writ petition without prejudice to his rights in deputy number and also permitted to approach the appropriate forum in that regard. Taking into account the above submission before closes the instant petition on withdrawal. However, the instant withdrawal of the instant petition shall not in any manner decrease the petitioner's rights and rights in the petition number 20, as well as also debar the petitioner from approaching the appropriate forum where the facts can be adjudicated.
Item 60.
Yes, madam.
In this case, my lord, the petitioner started when the petitioner 1 and 3 method. Therefore, after they paid some amount of money, it post of my lord, the bank, my lord. After the tip of the my lord successful certificate, they approach for the respondent, they disburse the amount. Thereafter, ultimately, my lord, only one amount, two amounts, my lord, that is lying with the post of the branch. All are received by.
Huh?
Out of this amount, my lord, they are yet to receive, my lord, two amounts, my lord. One from the savings bank and two, secondly from NSC, which are lying in the Vidya branch post of.
2,20,000 rupees and two national sector certificates. One, there is an account number losses against which is 2,20,000
In savings bank.
is a saving bank account number, and other two national saving certificates are being pending for Mirza losses, Mirza post office. Secondly, losses, we have received one instruction from the Mirza post office losses that we require some documents losses from her. The list is there, losses. If losses wanted to say, I can provide losses. List of that is the reason also we could not clear it. Not a copy.
So, madam, do you have this? You have the apply in the prescribed format
Already,
along with
my
the
lord, so I
succession
finished.
certificate. You have the succession certificate?
Yes, yes.
One. You have to give it the KYC documents is required, that you will do it. Of all the claimants and witnesses. Witnesses, who are the witnesses?
Witnesses at the time of lordship, at the time of opening the account, those witnesses lordship.
How will you get that? No, why do you need the KYC for those witnesses? The claimants is okay. Why do you need for the witnesses?
My lord, with the same document.
Why do you need the witnesses? How will we go and
Wait,
find
this
out
is
those
the-
witnesses?
yeah, that
When
is
it
the-
was
that is the
open,
thing,
how
that
do
is
you
the-
know and all this?
That is the thing, lord.
Only for the claimants. Death certificate of the you have it. Original passbook certificates, you have it. Of the deceased, you have it. Okay, I say that you are going to process that and not to insist on the KYC of the witness.
Lord.
The instant petition has been filed. Yes, you are paying for whom?
Important number 6.
Six?
Union
Yes.
Bank of India.
Ah.
But that only the succession certificate, certified copy has not been given to us.
They have already disbursed them.
Oh, it's not-
Already disbursed them.
Then the instant petition has been filed by the petitioner, seeking a direction upon the respondent to disburse the amount that are lying in the name of late Pulen Chandra Das with the respondent banks and post office as per the succession certificate granted by the learned district judge number 4 FTC Kamrup Guwahati in SC case number 382/2011 granted on 3/1/2013 on the date of late Pulen Chandra Das. During the hearing, Mrs. N.S. Thakuria, the learned counsel appearing on behalf of the petitioner, submitted that the petitioner have already received various amounts on the basis of the said certificates. However, is yet to receive an amount of rupees 2 lakh,
20,000.
Lying in.
2,12,000
Lying.
lying in the post office,
Post office savings account.
lying
I'll forward the-
in the post
It-
office,
it-
No, they reply to the.
post office savings account, Mirza post office.
Branch of
Saving account number, look at the account number is
Now give it to me. Lying in savings account number.
ask Pedal Lord.
Lying in savings account number.
Oh.
The savings account number 234102. Lying in the post office saving account number 234102 with the respondent number 2.
Yes, Mirza.
Respondent number 2. And further, 2 numbers of national savings certificate amounting to rupees 20,000. Full stop.
Before respond about.
Huh?
Before respond about.
Which is also and to it. Mr. Pancho, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3, appearing submitted that due notice have been issued to one of the petitioners for production of certain documents, and upon production of such documents, the said amounts would be released in favor of the petitioners. The said communication which was issued to the petitioner number 1 have been furnished before this court during the course of the hearing. That is a communication dated 12/12/2023. From a perusal of the said communication, it reveals that the petitioner has to apply for the said amount of rupees 2,12,000 along with the two NSD certificates. National NSC. In the prescribed format along with the succession certificate of the succession certificate, comma, KYC documents of all claimants and witnesses, comma, death certificates of the deceased depositor and the original passbook public certificate in the name of the deceased depositor for the settlement of death case. And look at the original passbook public the certificate in the name of the deceased depositor. Full stop. Mrs. N.S. Thakuria, the learned counsel appearing on behalf of the petitioner, submits that it may not be possible on the part of the petitioners to now produce the KYC of the witnesses. However, she submits that all other documents the petitioner would duly submit. So this court also is of the opinion that the KYC of the witnesses should not be made unnecessary. Is of the opinion that the KYC of the witnesses who were present at the time of opening of the bank account, as well as also preparation of, or also the obtaining the NSC certificate, is an unnecessary ask made by the respondent authority. Accordingly, this court therefore disposes of the instant writ petition, directing the respondent, directing the petitioner to submit the disposes of the instant petition, granting liberty to the petitioner to apply in the prescribed format along with the succession certificate, comma, and submit the KYC document of all the claimants, comma, the death certificate of the deceased depositor, and the original passbook public the certificate in the name of the deceased depositor. It is made clear that upon the petitioners applying, the respondent authority, more particularly the respondent number 1, 2, and 3, shall duly disburse the said amount lying in the post office savings bank account number so and so, number 2, along with the NSC certificates, and would not insist upon the KYC documents of the witnesses. The communication which have been placed before this court by Mr. So-and-so, the learned counsel appearing on behalf of the respondent number 1, 2, and 3 is kept on record and marked with the letter X. Why is this type of matter pending from 2016? Look nice.
17.
In this case, the petitioner had expired, that allows file the petition for.
Huh?
The petitioner has expired,
When?
on 31/3/22.
Then what are you doing?
We didn't know that he had expired, and only when the matter had come up, when he got contact with his son, that it got expired. He didn't have the knowledge that it expired. Because the case was last December 21, turned 21 a lot, and in between the case got listed.
Where is the order? If you order,
Yeah, page 66, your lord.
You were issued a notice,
Yes, sir.
Then?
That is, we,
and against that you have filed an appeal.
appeal.
Then,
Appeal got dismissed. That is
on the
why-
ground,
On the ground that there's no provision for appeal in the TF.
then,
After we have filed this petition in our court, and interim order was also granted, dated 25/8/2015.
Lordship, Mr. Esbora is on late for item 7. Mr. Esbora is on late.
Mr. Esbora is on lake. What do I do? No representation submitted by that notice. When did the petition expire?
31/3/2020.
What were you doing? 2 years?
We can get the information that the petition expired.
So, how do you know? How do you know now?
Because the case was dismissed by your lordship, and because we tried to contact number 10, but the home office father expired. We have now
So?
bring on the legal heirs.
So you bring in, this court is going to close this petition and repeat it. This court order, however liberty I will give you. But anyways, as of now, you see there was a notice issued against somebody. That notice has already become useless. You have challenged that notice. What remains now? When the person has died, would they not require to issue a fresh notice?
That your lordship, speak on record, your lordship. Right, not
Where is that notice?
Page
This is these type of cases.
40. Your
Huh?
lordship. Page 40.
See, this notice is to him. You do one thing. Yes, madam. I'll record your submission that you want to do something. Do so. Against now the petitioner has died. So you will issue notice upon the legal representative. Okay. Then we close it.
Yep.
Then what do you mean? You get the point. The petitioner having died, you may not be knowing what is the case about. Yes, let me explain. The case is very simple. A notice was issued to the petitioner saying that you are making some illegal constructions. Stop the construction. What he did, he filed an appeal against that before the district judge. The district judge dismissed it on the ground that there is no order. There's only a notice. So when only a notice has been given, how an appeal will lie? Against that, he has come before this court. Okay? And this court, at that point of time, granted a stay to him not to take any coercive measures of demolition. Meaning thereby, you are not in a position to do anything. Now what has happened? The petitioner had died. So if they do anything, you have to issue notice upon who is there, isn't it? Yes or no? Where is Mr. Esbora?
He's on late. Court file.
No GMDA. GMC? No GM. No other. Mr. P. Nayak, not there. You are not a counsel. That is the problem. So you have to issue a fresh notice. If you have to issue a fresh notice, if I put that, I close the petition, do it. And then let him do. Otherwise, he's enjoying for the last 7 years. Not 7, 9 years. Unnecessary. So get hold of Mr. Esbora He'll finish up this matter today itself
You'll be
with your undertaking. He'll issue fresh notice, then nothing remains against the dead person. Your purpose is, sir, you don't need to implead. You wait, Mr. Das, you wait. Once Mr. Bora comes, I'll finish it up. Yes, what is your case?
Here petitioner, they applied for they applied for flat from the housing in the year of 2007. But without considering my application, the commissioner, respondent number 5, considered the application of respondent number 8, who applied in the year of 2013. And the respondent number 8 is the sister of respondent number 5. It is the commissioner. And that is my query.
Is a sister of?
Respondent number 5, Lord, it is the commissioner of board.
How can a person be a sister of an office?
No, no. There's the respondent number 7 is, and the respondent number 5 is the same person.
Huh?
Respondent number 7 and the respondent number 5 is the same person.
Respondent number 7 and respondent number 5 are the same person.
Yes, Lord. Respondent number 5 is the commissioner holding the post of commissioner Assam State Housing Board.
And it was given to respondent number 8
Respondent number 8 is the sister.
of?
Respondent number 5.
Okay. Who is appearing for them? What is their stand?
T.R. Gugoi appears for the house. He is on his way. Can it be taken up?
And who is appearing for the private respondent? What about the respondent number 8?
Only respondent number 3, 5 and 6 and 5.
You applied when? Yes, Mr. Gugoi, what is this? Why are all different persons filing?
Lordship, petitioner number 1.
And everybody is filing and fighting for only one flat?
Not for specific flat.
Yeah, everybody is challenging the quashing and allotment of so-and-so of the respondent number 8.
Yes, Lord.
Issue a direction directing the AR to take steps of demand. Why are 3 persons filing against one?
Lordship, petitioner number 1 applied in the year of 2007. Petitioner number 2 applied in the year of 2008 and 3 in the year of 2009. But the respondent number 8 who applied in the year of 13, commissioner, that is the respondent number 5, he allotted the flat to the respondent number 8 in the year of 2014. But prior 3 or 4 years ago, I have applied for the flat, but they have not considered my application.
So, okay, I allow the repetition, then you are going to fight amongst the petition. Are all the petitioners not having a separate cause of action?
Actually, at that time,
Or you need more people to
no,
voice out?
at that time, these 3 persons were applied, and at that time there was
So all has a different right? Anyway, Mr. Gugoi, what is this? The
Lordship,
allegation is, how do you allot? First come, first basis or what?
Actually, fact is that not to I missed this step matter. That's because of that our
Okay.
name not has been thrown in false paper.
Take-
I may be allowed at least 1 week time.
1 week, no. 1 hour time. Take my file. We'll take it up at 2.
Lord,
This is a 2015 matter.
Lord.
Uh,
Lord.
week, 1 hour.
this
Yes.
matter. The Doloy of District
Hoyogriv Madhav temple for your daughter. It aggrieved by the impugned order at page 29, impugned WT message, which has brought in a ban on animal fight. Reference that state WT message is to the two-judge bench decision animal welfare.
Wait.
Sure.
What are you asking, madam?
Where my lord,
First of who are you?
I am presented. I am the petitioner number 1 is the temple lordship. And number 2 is the
Petitioner number
Lord
1 is the wait.
temple. Sri
Ah, is
Hoyogriv
the
Madhav.
temple. Okay, then
And it is represented by the Doloj. Shivaprasad.
okay, then what happened?
Lord, we are aggrieved by this order. At page 25, there was an order passed by the circle officer, respondent number 4,
I am
13150.
John of Good here with
This
the
is a
direction
letter
that it is regarding prohibition of animal races and fight in the light of the Honorable Supreme Court order. You are requested. What animal races you have?
This is a bulbul fight.
Or bulbul fight? Then
The red painted bulbul fight at the Hoyogriv Madhav temple on 13th or 14th of January.
okay. Then
So, my lord, a ban was put in, and the reference in that order was to the two-judge bench decision at page 30, Animal Welfare Board of India versus State Nagara.
so what does it say?
This was the basically on the Kalikatu event that takes place at Tamil Nadu, Karnataka, and Maharashtra.
Yes. Then what was the cruel practice and violation? Fighting a full state, welfare measure, twisting of full state, cooking fools with knife.
Finding your lordship will find at page 54 of the judge. Fools who are pushed, hit,
Before
prodded, and abused in Kalikatu suffer
Eh.
mentally as well as physically.
full hearted. 850 conclusion. Then
There is also the injuries and death that was recorded.
where is
So,
the
my
ban?
lord, the direction was to after this a ban was put in on all animal fights
Where?
in Assam also at page
On the
29.
basis of this judgment.
Yes.
Then
Then, my lord, in the meanwhile, we approached this honorable court, and on 22/12/2015, the impugned order was put in abeyance.
so now you can have the bulbul fight.
My lord, in a way we can,
Hmm.
but the Animal Welfare Board,
Where is the stay?
the order lordship is dated 22/12/2015. Second last paragraph, the materials in the case suggest that was arrived at by the authorities on cruel treatment of the Buddha's part during the ritualistic fight in Hoyogriv Madhav.
So it has been stayed.
Yes, my lord.
Then what happened?
Thereafter, my lord, the Animal Welfare Board had approached this honorable court, and on 12/1/16, the honorable vacation judge has passed
12-1?
on 12/1/16. The vacation
12-1,
court-
we don't have 12-1/16 anymore.
May I interfere in between?
Please do interfere.
Yes. Kasif, in fact, the matter last came on 10/10/2023. On
10-10?
2023.
I don't know. The last came on 15/2/2023.
Yes, Lordship,
No,
and
this is-
I had.
This is another case which is connected with this one. That is with regard to the long pending issues of Bulbul fight and the buffalo fight that takes place in the traditional way during Bihu. So accordingly, the government has been asked to take a decision as regards what can be done next. So the cabinet sat over the matter. A decision has been taken that all traditional fights that have been taking place for years together will go on. And accordingly, a standard operative procedure has been issued by the Home Department. So accordingly, as per this operative procedure, very well the bull fight and the buffalo fight can go on if at all they comply with the norms that has been given. So nothing remains.
Lord, and similarly situated persons from that Ahadpuri Mojud committee were also reported on
Yes,
court
maybe that is the case.
on our
Bulbul
high
fight.
court.
Background of the Bulbul fight. Standard operating procedure. Bulbul fight. Bulbul fight should be kept completely safe. Hard items, food items and water to be fed to the Bulbul for the benefit of safety and security. The game of Bulbul fight must be conducted in a well in the game. Bulbul fight bird fight the management owner shall use set up barricades and stop the game for the two judges. What is this?
This is another order passed by this honorable court in a case filed by the Ahadpuri Mojud committee. Therein the buffalo fights are conducted, Lord.
Okay.
And our high court has, based on that cabinet decision, both of was on 12/12/2023.
Now here is the cabinet that may be taken. So this is the cabinet decision.
Yes.
So this is prior to.
In fact, that case reference has been brought in that notification.
My Lord,
No, now you are going to hold it as per this standard operating procedure.
Yes.
Okay. So we dispose it in this term.
Lord, and on 18/5/23, the Jallikattu event was also correct. Since notifications had come out in Karnataka, Tamil Nadu, and Maharashtra, the 5 years bench of the Supreme Court had also allowed the Jallikattu fight.
So this order was reviewed. The
So, my Lord, this was
judgment in
referred-
that case
So, my Lord, that was referred to the
to a larger
final-
bench. So that judgment is no longer there in view of that the constitution bench. Who is appearing for the impleadment persons? No, no.
That could
Okay.
be-
Heard Miss P. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. S. Burua appears on behalf of the respondent number 1, 2, 3, and 4. The instant writ petition has been filed by the petitioner challenging the order dated 13/1/2015, whereby the circle officer, Hazo Revenue Circle, Hazo had prohibited had informed the Doloi of the petitioner number 1 about the prohibition of animal races and fights in view of the judgment of the Supreme Court in the case of Animal Welfare Board of India versus Nagraj and others, reported in 2014 7 SCC 547. This petition was filed on 7 8 people write it in such a language. Was filed on 28/8/2000. No, 7/8. No? When did you file? 7/8/2015. And the coordinate bench of this court, by the detail order dated 22/12/2015, had stayed the ban order dated 13/1/2015, addressed by the Hazo Circle Officer to the Doloy of the petitioner number 1 until further orders. First, it is relevant to take note of that the petitioners it is relevant to take note of that during the month of Magh, Bihu, at Sri Sri Hayagriv Madhav Temple, red-vented bulbul play the game bracket 5 this auspicious fervor of the game bracket 5, as per the petitioner, has been continuing for the last 400 years or so, and is associated with the worshipping of Lord Hayagriva and associated with the custom of satisfying the deity late Lord Hayagriva of Hazu. It is also mentioned that it is only at the sanctorum of Sri Sri Hayagriv Madhav Mandir that the Bulbul fight take place. That too only on the auspicious first day of Makar Sankranti, celebrated as Magh Bihu in Assam. This court have also taken note of the order passed by the coordinate bench on 22/12/2015, wherein the coordinate bench had duly taken note of that the judgment of the Supreme Court in the case of Animal Welfare Board of India, SUPRA, was rendered on the facts of that case, taking into account that there were materials available as regards cruel treatment to the bulls, which, however, was not there in the case of bulbul birds during the ritualistic fight in the Hayagriv Madhav Mandir. This court also finds it very pertinent to take note of that on 27th of December 2023, an SOP oblique guideline have been framed to ensure that buffalo and other traditional bird fights are allowed to be organized in all places where it has been traditionally organized, with specific provision for regulation by the district administration to ensure that cruelty to animals is not allowed to be inflicted. In the said order, notification dated 27/12/2023, the background of the bulbul fights have also been taken note of, and also the fact that note of, as well as also the pendency of the present writ petition. This court finds it very pertinent to take note of the standard operating procedure (SOP) for bulbuli bird fights, which have been mandated in terms with the notification dated 27/12/2023. The said SOP, as is pertinent for the purpose of the instant writ petition, the relevant part of the said SOP, as it is pertinent for the purpose of the instant writ petition, is quoted hereunder. Taking into account the notification dated 27/12/2023, it therefore transpired that that the government of Assam would no longer be insisting on the impugned order dated 13/1/2015. The government of Assam further have already mandated an SOP which the petitioner have agreed to follow. Accordingly, this court therefore disposes of the instant writ petition by setting aside the impugned order dated 13/1/2015 and with a further direction upon the petitioner to comply with to take appropriate steps for compliance in terms with the SOP for bulbuli bird fights as mandated in the notification dated 27/12/2023. The said notification is kept on record and marked with the letter X. And 2015 matter. Yes.
Please, Your Lordship. Lordship, it is regarding the release of the project fund, Your Lord. The court have directed the state of Arunachal Pradesh to file. They have filed the affidavit.
What do they say?
We stand by that earlier. Stand by that earlier. Your Lordship wanted us to clarify whether we.
So then what do you do?
Your Lordship, I have
The
communicated.
committee has cleared it, right? Only for them to take.
No, they are
I'm
not
pre-
saying it, but do you, when the deputy commissioner had categorically, therefore this court had passed an order earlier, na?
Lordship,
We file an affidavit.
Mr. B.D. Goswami shall obtain in necessary instruction as to whether the deputy commissioner comes so and so, stands by the minutes of the Iman, more particularly to the effect whereby the House had recommended for immediate release of the balance amount of rupees 4.63 lakh to the petitioner against them. The court has found sought for the above noted instructions in view of the fact that the perusal of the sanction dated so reveals that the DC UPA Papunpara district was requested to act as the chairman of the PIA, wherein the petitioner was the conveyor. In the said sanction, it has been mentioned that the implementing agency has to make presentation on the project to the deputy commissioner for the purpose of the detailed discussion and approval, and the implementing agency should keep in touch with the district administration at various stages of the implementation for it. List the matter on here for obtaining the instruction to be put on effect.
Our affidavit dated 2012.
Black C.
Verify. Also, penalty annexer. Page 3.
Yes, what are you going to do?
Your Lordship, I have communicated about this information, Your Lordship, with the NABARD authorities. I am praying for 1 day time, Your Lordship. It can be taken up tomorrow.
Day after. List the matter on 10/1/2023 for further consideration. Yes, what is this?
For time.
What?
For time being.
Why you are asking for challenging? Again, housing board. Yes. Where is Mr. T.R. Gogoi? Yes. You have lost this file also?
I am not at on his boss system. That's why I again made this later.
You do one thing, this and the other matter. We have it on 10, showing your name. Okay? Earlier,
18. Earlier was 18.
18 or 20. Do it. This is 20.
It's 21.
18 and 21. List the matter again on 12/1/2024, showing the name of Mr. T.R. Gogoi, the standing council of the Assam State Housing Board.
Got
Hmm. 12.
Got
Both.
Got Marshall.
Man, पुराना केस and appears on behalf of the petitioner on cause. It seems the petitioner is no longer interested in the matter for which the instant petition stands dismissed for non. None appears on behalf of the petitioner on call. It is further seen that the petitioner had also not been represented on the earlier occasions also. So taking into account above, the instant petition stands dismissed for non-petition. Yes, why is this so
My lord,
big?
this is all these bills, my lord, of hiring charges, my lord, that non-payment of. And the respondent has paid that some amount. They filed an affidavit, and they paid a charge in this affidavit, and it is still is 2 crores 55 lakhs 89,197 is petty. Still,
How much?
my lord, more than 2 crores 55 lakhs 89,197 is petty. The charge
They
is
file
there, my lord.
affidavit.
Yes, your lord. That affidavit, your lordship, at 28/7/2017. Chart is that is 5, my lord. They have made pending. It is 5.
Yes.
Effect,
You consider and verify and pay 6
Right.
months.
Yes.
That is the only thing
Yes.
the court can. Nothing else. Because there is no denial in the
No denial.
affidavit out there that they are not entitled to. They say that we have paid 71 lakhs and remaining out there, it is to be paid out there, it's been sent to the higher authorities out there and they don't have the power out there to do so. So the higher authorities has to consider. So a direction is.
the undisputed amount will definitely be paid
Huh?
within a time frame, maybe that
6 months or 1 year. 1 year. Taking into account that the petition is back. How many percent? 1%.
So, my lord, this, all these bills are paid through the association. That's better.
How is it possible? Tell me.
Bills have been
Is
paid.
it being done by the
Yes,
association?
I know. But that the association is taking care of all these things. Then.
This can't be. This has to be person concerned. The association cannot. How can they verify?
Well, they have made a chart. They have made a chart.
Who?
That, affidavit.
I've seen that chart.
Yeah.
That chart
that's
is
what it-
okay. But how is the you
Bills are
see
there, madam.
today I direct.
Yes.
Okay, within 6 months you consider and pay. Then who is going to come? In contempt, somebody has to come. Who is going? How?
They are the representative of the association, and the association is taking care of all these things. Because some the persons, without being a member of the that they are taking something, some unused advantage. That is it. That's why.
The instant writ petition has been filed by an association in the name and style of Kokrajhar Omni Tourist Vehicle Owners Association. The grievance of the petition association is that its members have vehicles of its members were taken on hire by whom? By the various governmental authorities. Others have not filed by the various. No, you are only 7. 7 is only the police. Has it only been
Mainly
taken by the police or it?
Mainly
No, you
mainly put it.
have been taken on hire by the various governmental authorities. Various state authorities. However, upon the bills being submitted, the same have not been cleared. By the concerned respondent authority. The record reveals that an affidavit has been filed on behalf of the respondent number 7 by the Superintendent of Police, Kokrajhar, wherein it has been mentioned that a part payment of rupees 72 lakhs 17,443 have already been made to the owners of respective vehicles, and all the bills have been submitted to the higher authorities for making payment, which is under process. The bills which are under process have also been mentioned in the said enclosure to the affidavit filed by the respondent number 7. And these bills relate to the Kokrajhar district only. It is the opinion of this court that if the vehicles of the members of the petition association were taken on hire, the said members, the members of the petition association would be entitled to the amounts as per the government rates, higher charges on as per the government rates. And depriving the said amount to the members of the petition association would be arbitrary and unreasonable. Under such circumstances, this court, therefore, this court also cannot be unmindful of the fact that the actual entitlement of the petition, members of the petition association, has to be verified by the respondent authorities. And without a proper verification, no amount can be directed to be paid. Under such circumstances, this court therefore disposes of the instant writ petition, directing the members of the petitioner association to submit their individual bills, to submit their individual claims before whom?
Before the respondents.
Whom? That is the problem, no? All this problem arises. You want a very vague
Sir,
judgment
respondent
order.
was, my lord, 3291.
How? How can it be given to 329? You see, tomorrow you are going to file an FIR against the contempt against whom? You have to think when are you passing
Yes,
the
sir.
judgment.
That situation is
It becomes very difficult.
Yes,
Why you are making everybody? I can't even direct one person. You see, people in Kokrajhar, Bongaigaon, Chirang,
covered.
before the concerned respondents, numbers 3 to 9, along with all the details of the bills, the said respondents to whom the members of the petitioner association shall approach respectively, shall verify the entitlement of the members of the petitioner association. This court also cannot be unmindful of the fact that this verification would take some time. And thereupon, there would also be requirement of following certain process for the purpose of disbursement of the amount, if found upon verification. This court therefore directs the concerned respondent authorities to complete the entire exercise within a period of 1 year from the date each of the members of the petitioner association approaches the concerned respondent authorities.
Yeah, before 9 months.
15 months.
My lord, that one.
In a period of 15
One
months.
year, my lord. 1 year. Hello.
Where is Mr. Bora? S. Bora.
Bora was here.
Get hold of him.
I may be allowed to withdraw.
With? Only withdraw.
But it-
Mr. So the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition, taking into account the above, the instant writ petition stands closed on withdrawal.
Other 26 also same. Item number 26 also same.
Mr. Bora is not there, and I could have relieved Mr. S.P. Roy. Yes, Mr. Roy, you are here. In your matter, you see, your person has died. I was asking the GMD that as the person is dead, the notice, you have come against the notice.
Yes.
So the notice has become useless. That is why I wanted Mr. Bora. He will issue a fresh notice to you, to the persons, because a notice against a dead person becomes useless because you have come against a notice.
Yes.
So that is why I wanted to close it with that. But whenever he's not available. Okay.
Case is against GMD, not against him.
No, GMD, I think Mr. Bora appears. He appears out there. Either Mr. Nayak or Bora, or we have the chief executive officer in the video conferencing.
Yes.
We have the chief executive at 2 o'clock video conferencing. Better off. If they are not so busy, if the GMD authorities are so busy, so if they are not there, we can ask these people. Because unnecessarily,
I contacted
whom you have contacted?
Or-
You contact the chief executive officer and tell him that to be present at 2 in video conference. I'll tell him. Because when we don't get the councils out here, what to do? The chief GMDA is too big an authority to have the control of only 2 councils. They have, I think they have matters. So if they are not available, what to do? I'll take it up at 2. If he is not available, ask the chief executive officer to be present at 3. Video conference. Mr. Bora, you see, here the show cause, it was a show cause proceedings. Show cause proceedings was issued against the petitioner. Page 40. Against this, he challenged it before the district judge. District judge dismissed it on the ground that there's no order passed and as such jurisdiction was not there. Against that, he has come before this court. And there is a order that no coercive steps for demolition should be carried out. In the meantime, the petitioner counsel says that the petitioner had expired. So these show cause proceedings can no longer survive. If something has to be done, then you have to issue a fresh show cause notice. Isn't it?
But at the same time, I have to point out under section 71, any order passed by the chief justice has attained final.
Huh?
Any order passed under section 71, it will attain final. But if there's something it is
71 of
of the GMDA, the chief judge it will attain final.
understood.
But now the
But the
situation is-
no, 71 is finally it is. But the fact is the appellate authority did not exercise jurisdiction
Okay.
because of the fact that there was no there is no order passed against the notice. There is no question of issuance or there is no appeal arise. That is the finding. Now this is a show cause proceedings. So if you are to issue now, you have
It
to
is
issue
a-
against the
separate.
well.
Not-
The instant writ petition has been filed by the petitioner, challenging the order dated
page 63.
3/8/2015 passed in Miss Appeal number 36/2015 by the Additional District Judge number 2 Kamrup Metro at Guwahati. The facts which is discernible from the perusal of the writ petition is that a show cause notice was issued to the petitioner on 27/5/2015. Under section 87 of the GMDA Act to stop forthwith the deviated construction and show cause within 10 days of receiving of the said notice why the unauthorized building should not be demolished under section 88, bracket 1, or seal the unauthorized erection or work of the premises in which such work is being carried out or completed under section 88(4) of the GMDA Act 1985. 1985, na?
Not 85. Okay.
Full stop. This so-called proceeding was put to challenge by the petitioner by filing an appeal before the appellate authority, that is, the district judge. Kamrup Metro at Guwahati. Full stop. The said appeal thereupon was transferred to the Court of the Additional Session Judge number 2, Kamrup Metro at Guwahati, for disposal. By an order dated 3/8/2015, the said appeal was not entertained, taking into account that an appeal lies under section 71 of the GMDA Act 1985 against an order. However, as the appeal was filed against a show cause notice, the said appeal was not maintainable. It is under such circumstances the petitioner have assailed the order dated 3/8/2015, passed in miscellaneous appeal number 36/2015. Full stop. Upon the incident writ petition was filed, this court had issued notice and also had directed the respondent authorities not to take any coercive steps by way of demolition in respect to the building constructed by the petitioner. Full stop. Mr. S.P. Roy, the learned counsel appearing on behalf of the petitioner, submits that the petitioner had expired on 31
31st 3/20.
Huh?
22.
When?
22. 31st 3/20.
31/3/2022. Taking into account that the entire proceedings arises out of a show cause proceedings initiated against the petitioner, who is no longer alive, the said show cause proceeding, therefore, has become redundant in view of the death of the petitioner. Consequently, therefore, the said show cause proceedings dated 27/5/2015, issued by the Chief Executive Officer. Consequently, therefore, the show cause notice dated 27/5/2015, issued by the Chief Executive Officer, Guwahati Metropolitan Development Authority, is set aside and quashed, as it had become redundant. Full stop. It is, however, made clear that the setting aside and quashing of the said show cause proceedings initiated on the basis of the show cause notice dated 27/5/2015 by the Chief Executive Officer, GMDA, shall not preclude the GMDA authorities to take appropriate steps in accordance with law against the legal heirs, against the legal representatives of the petitioner, if so advised.
Sir, I am having item number 49. to
Interim
50.
orders to pass, stands Vicky.
Lordship, I am having item number 49 to 50. I am suffering from fever, Lord.
Okay, we take up item number 49 to 52 now only.
I am suffering from fever.
Huh?
I am suffering from high fever. Next week, any day,
Which year?
2015. 2015 case,
Item number 49.
49 to 52, all are connected. Take on tempo.
922.
Next week, any day.
No. I'm not going to adjourn any of these matters. Sorry.
I'm suffering from
If
fever.
you want, I'll do it the matter now. 2015 matters, I'm not adjourning anything.
Then take tomorrow. Lo.
No, now.
Lordship, I'm suffering from fever. Lo.
Let us see what is this. Why the matter has come up for orders. I'm giving you the opportunity. You are here. So let us see why the matters are being required to be taken up. I'll pass some orders if it is necessary. But to adjourn a 2015 matter, I'm not going to do that.
It's only today, it's only for containment.
2015 contempt matters. What is this?
Matter is this, Lordship, I'm the honorable plot of I was picked by circle officer at it forcibly without giving any notice. Then I approached this honorable court by a petition.
First is contempt case number 318 of 2015. Who has filed it? You have filed.
I have petitioner
Okay. Against
against the
Nirmal Kumar Sharma, the resident of so and the officer in charge. What is the order passed?
first was Lordship, the official correspondent, the primary directed to maintain the status. By violating the status order, they
Where is the order passed? 2/3/2015 in WPC number 84, Annex 12.
have 39.
To notice of motion, there is no need to take formal step. Step up. Status quo as of today, respect to the land which shall be maintained on the next day. Then what happened?
They Lordship, they violating the status order, they demolished my or boundary was my house and erected iron gate.
Then what happened to the writ petition?
Writ petitions are fixed for head final.
Where is it? There's some.
All writ petitions are fixed.
I think. Eight four eight 40. Item number 51. आए की कौन IA number 51 2015. এই কোন 476 Yes, Mr. Roy, here at page 40, the status quo as on today in respect to the land in question shall be maintained until the next date fixed. Issue notice returnable on 1/4/2015. Okay? Kindly come to page 40 of your contempt petition. Okay? Now, if you kindly come to page 8 of your contempt petition, paragraph number 18. Page 8, paragraph 18. The status quo order was valid till 1/4/2015. Your allegation is on 18/4/2015, he had started digging. The interim order was not extended on 1/4/2015. List after one Bihu vacation, as prayed for, list after so and so, there is no interim order. Well, under such circumstances, where is the contempt? There was no order. Withdraw. Okay. Tomorrow, item, first item, all these matter. At the request of the learned counsel for the petitioner, matter to be taken up tomorrow at 10:30, 10:15. Good evening. Yes, what is there?
As per instruction at present, all the municipal boards are being headed by the chairman.
And
Then why do you
there is
need
a
the chief?
provision also for the chief executive officer, who is as per the section 53, there is a chief executive officer who look after the implementation of the orders and others. May read this section 50 of the act. The function of the chief executive officer is defined in section 52. Sorry, Lordship, the executive officer, not chief executive. Executive officer, not chief executive officer.
No, therefore, if there is no chief executive officer, how can this court implead somebody who is not there?
But it should be, it should have been the executive officer, not
No,
chief
executive officer only comes into play when the
When there is
AI
no
is
court.
not there.
executive. The executive officer
I mean,
53(2) says the executive officer shall function under the overall control.
understood. When does the executive officer come into being?
Board is not functioning.
The board has to be superseded. Let's see how the executive officer is appointed.
It is appointed by the state government. Section 50.
Appointment of the state government shall appoint an executive officer for each and every municipal board and shall bear the expenditure in respect of a year. In the municipalities having a population of one, an officer of the level of the one shall be posted as the executive officer, and in all cases the government may put one executive officer in the charge of state municipal. Mr. Council, you do one thing. Your application is for chief executive officer. Remove, you withdraw this and file an application making two persons, not only one. One, the state of Assam represented by the urban and municipal administration.
Municipal administration.
A municipal administration, there is a department out there. And second, you make the executive officer. Okay? You withdraw this and file a fresh one. Because without that, you can't have a control over them. And they are not representing. So to effect that orders, you have to have the state.
Yes.
So that is the reason why. I think you better withdraw
Yes.
and file a fresh one.
I'm obliged.
Mr. So the learned counsel appearing on behalf of the petitioner submits that he would like to withdraw the instant application with the liberty to refile it, taking into account that there are certain, taking into account that the petitioner is required to implead the state of Assam represented by the secretary, commissioner and secretary,
Commissioner Secretary,
commissioner and secretary,
municipal and
municipal administration, as well as the executive officer, so appointed under section 53
Yes.
of the Assam Municipal Act 1956. Taking into account the above, the instant application stands closed on withdrawal. However, the petitioner is given the liberty to file a fresh application to implead the necessary parties as above mentioned. Let him file. If he doesn't file, what do I do?
27.
Yes,
I think nothing survived. That is very clear.
what is this, Mr. Goswami?
My lord, the petitioner alleged the tender process was proceeded with, my lord.
Directing the respondents to cancel the impugned tender.
Yes, yes.
Tender.
That, according to him, it was done secretly. Biasness is there.
Work completed.
My lord, subsequently, I think, my lord, during the pendency of the tender process, my lord, the water level was rising. That is why at that moment it was, my lord, stopped. Till that time, I knew it.
Huh?
Till that time,
because the authority could not issue the work order because of the rising of the water level
Hmm.
of the. But in any case, my lord, their allegation against the allegation, we have filed an affidavit. my lord.
No, understood.
Right.
But the petitioner is not represented on many
On many
occasions.
occasions. That is right.
Not only that, this tender process is of the year 2017. What
17.
remains?
Nothing.
Alleging serious anomalies in the tender process initiated by the water resource developer pursuant to the invitation of so and so.
Yes.
Iman. The North Assam have approached this court internally containing that the process to which the work was appointed in favor of the son is vitiated on account of total arbitrariness and the award has been given.
My lord, when the, to that extent, my lord, I was informed, but thereafter, my lord, whether
What
the
did your affidavit say?
affidavit against this allegation, there was nothing wrong on the part of the authority while proceeding with the, my lord, tender process. That was there.
None appears on behalf of the petitioner on call. The record further reveals that the petitioner has not also is not being represented, have not represented itself on various occasions. Taking into account the above, this court, it is the opinion of the court that the petitioner seems to be not interested in the instant proceedings, for which the instant petition stands dismissed for non-prosecution.
Made Your
Hmm.
by person they ordered at 8/11/2023. They have to file the affidavit. They will have to file a affidavit by the order dated by the 8/11/23.
Yes, they have filed an affidavit pursuant to my order.
My lord,
Obviously,
my lord, we have received the instruction, my lord, but somehow, my lord, maybe fix in the next week, my lord, or my lord, Friday.
Hmm?
We have received the instruction.
When
my
are
lord.
you filing it? Because
Let
this
us see.
needs to be filed by way of an affidavit.
Affidavit, my lord, so my lord, maybe. the
Because
next week,
what you have done,
my lord,
something has to be done because we clarify in which dark number and patta number petition and land is mutated on the basis of the order dated demand.
8 bighas land,
Because he has 8 bighas.
my lord.
So he has been made. Okay. Mrs. Yu Das, the learned counsel, learned additional senior government advocate submits that the instructions have been duly received pursuant to the order dated 8/11/2023 and the affidavit so directed to be filed would be filed within a week's time. List the matter again on 5th of February 2024.
Deeply obliged.
In the meantime, the affidavit be filed by 30th of January 2024 without fail.
Obliged.
30th of January.
My lord.
29.
May I please, lordship, in item number 28, I'm for the respondent number 4.
Give your name, your senior's name, everybody's name, everything will be put out there. I don't put
Okay.
anybody's. Yes.
If that is not payment of forfeiture, it
Then
at present whether the amount or not have the information. But matter is the
Even I don't have the instruction note.
Why?
In fact, what if it's 17 days?
Oh. The instant writ petition has been filed by the petitioner, being aggrieved by the inaction on the part of the respondent authorities in not making payment of the amount of rupees 9,23,045. And accordingly have sought for a direction upon the respondent authorities for payment of the said amount along with interest. The facts as could be discerned from a perusal of the writ petition is that the respondent herein had published a notice inviting tender in the irrigation department under the scheme, inverted comma, Laipulia Elias, bracket, under AIBP, bracket close, inverted comma close. And accordingly, the petitioner being eligible had submitted the tender. Pursuant thereto, a work order was issued on 15/11/2010 to the petitioner. It is the further case of the petitioner that the petitioner had duly completed the work and the respondent authorities have also given a completion certificate. The petitioner also raised the total bill of an amount of rupees 49 lakhs 1,000 49 lakhs 49 comma 01 comma 000 49 lakh 1,000. However, out of the same, the petitioner received 39 lakhs 77,955. The petitioner therefore claims that the petitioner is further entitled to an amount of rupees 9,23,045. The petitioner had submitted on various occasions representations before the respondent authorities for payment of the said amount of rupees 9,23,045. But however, the said amount having not been paid, the petitioner has therefore approached this court by filing the instant writ petition. During the course of the hearing, the learned counsels appearing on behalf of the petitioner as well as the respondent submits that they have no instructions as to whether the petitioner in the meantime has received the amount or not. Be that as it may, it is the opinion of this court that if the petitioner is entitled to the said amount, the respondent authorities are bound to pay the said amount. However, as to whether the petitioner is entitled or not to the amount of rupees 9,23,045 or any other amount in respect to the said contract would require certain verification to be carried out by the respondent authorities. Accordingly, this court therefore disposes of the instant writ petition with a direction to the respondent authorities to verify as to whether the petitioner is entitled to the amount of rupees 9,23,045. And upon verification, if it is found that the petitioner is entitled to the said amount to claim or any part thereof, the same be paid to the petitioner. The said exercise be completed within a period of 4 months from the date, from the date a certified copy of the instant order is served upon the respondent number 2. It is, however, made clear that if in the meantime any verification has already been conducted and the petitioner have also received the amount, or the petitioner have been duly intimated that the amount that the petitioner is not, if any verification has already been conducted and the petitioner have received any amount, then in that case, the above exercise may not required to be carried out.
Obliged, Lordship. Very obliged.
Make me a little.
I thought your lordship may see the order dated 15/12/17 May.
What?
So you have been evicted.
Not really.
So you have no case.
But my terminal this matter, on that my notice of evicted matter, till today matter, the government has not filed any.
Okay, but the
application for-
government won't. The government is not interested in throwing you out.
This matter of, I don't seventeen matter, it was by fix the date of hearing matter, if they,
What?
no, if they does not file any opinion
Not
opposition matter.
necessary.
I'll submit. And my petition for allotment of the area is pending before it approved. In 2009.
How does the petition number 6 come into the scene? Huh?
Yes, my petition number 6 minute.
Now petitioner number 6.
Yes, sir.
How does he come into the scene? All these documents have no relevance with the petitioner number 6.
Yes, but that is my submit matter.
Or just
At that
included
time,
somebody else.
at that time I could not submit that document also matter. I will fetch now. Yes, yes. But all the time I could not collect my, the hurriedly file matter. Petition was filed hurriedly.
Hurriedly, 8 years have gone.
Yes, ma'am.
So hurriedly, you should have
No, no.
done some improvement. in it.
But,
And you are now required to file it as per the new scheme.
My lord.
If this has not been done till now, you file it as per the present one. And you file it within 30 days. And till the disposal, if you file it within 30 days, they would not take any step for eviction till the disposal of that application. That's all. That's the best order you can get. Because now the land policy has changed.
Changed, my lord.
Yes.
And in the
Now, if you want to get the amount, land or whatever may be, you have to apply.
my submit this matter, my petition put out is pending for allotment. That is pending. That may be considered, right?
What?
That is matter, on that application, matter, no order has been passed yet.
No order is passed very well. They are not inclined to pass any order. Why there is no instruction?
my lord.
Because there is no stay.
Lord.
And you have not
No.
thrown them out also.
There is no statement.
Mrs. A. K. Kumari, the learned counsel appearing on behalf of so and so, had submitted that Mr. Mohammed is in bereavement and the case be listed after next week. So you knew the matter came, therefore the matter has come. You are now over bereavement.
No, no.
There's no more bereavement.
On that matter, I was in my junior fifth time matter.
Absolutely. So you knew the matter was coming. And then why didn't you do anything?
After 17 matter, only 2-3 days comes matter. That was matter, it is 2023 and 20.
Hmm?
Matter came up for honorable court on 17 matter. Only 3 or 4 days the matter has been before honorable court matter. And 2 days I had taken because of my illness matter. That is that.
Yeah, it was only a apprehension.
On
Now, as of now, the land policy of 2019 has come in.
Okay. Yeah.
So you are to be now regulated as per the land policy of 2019. Yeah. And land policy of 2019 also takes note of that those people who have been there as per the land policy of the 1989, more particularly in 2001, they are entitled to remain in possession thereof.
Right.
Your admitted case out here is that you have been in possession of this land from 2008.
My lord, only one thing, my lord. In the representation, my lord, page 14, in the vernacular, my lord, there is a page 14, my lord,
Yeah.
vernacular. 8 নং দাগৰ শ্ৰেণী নাই ৰিজাৰ্ভ দাগৰ অংশৰ ইমান কথা মাতি
But in the translation, my lord, that reserved dark, my lord, that is not, my lord.
Oh,
So, my lord, maybe it's
reserve
a-
down.
the translation English that reserved dark is not there.
But regarding petition number 6, my lord, I may be allowed
And
to
in the
file my
vernacular,
additional
my lord, they have
expense.
enclosed some documents, my lord, which are not enclosed there.
Oh. The instant writ petition has been filed by the petitioner seeking a direction upon the respondent authorities for allotment of the land to the petitioner, and also pending disposal of the instant writ petition, the petitioner should not be evicted over the land presently under their occupation. It is the case of the petitioner that the petitioners have been occupying the land in Dag number 8 of West Dhaniram Pathar of Hosai in the district of Hosai since 15-20 years ago, and that they paid Tozi Bahi revenue from 2008. Before proceeding, this court, however, finds it very pertinent to observe that payment of Tozi revenue is only a payment of a penalty for unauthorized occupation of government land. Be that as it may, the petitioners number 1 and 2 had submitted a representation dated 21/12/2008 before the Department of Revenue through the Forest and Tourism Minister, Government of Assam, and they were awaiting allotment of the government land and foodstuff. It is also mentioned that the other petitioners have also approached the Deputy Commissioner verbally and physically requested the Deputy Commissioner to allot the proposed land for allotment in their name. So it is also mentioned in the writ petition that there are certain correspondences initiated by the circle officer as regards allotment proposal, as regards the applications so filed by the petitioners for the purpose of allotment of their land. Be that as it may, there has been no allotment. There was no allotment. Be that as it may, there was no allotment of any land in favor of the petitioner, and the petitioners still are occupying the government land. It is the further case of the petitioner that the petitioner could come to learn that there was an attempt to evict them, for which the instant writ petition has been filed. The record reveals that this court, by an order dated 15/12/2017, had issued notice. There was no interim order so passed. It has been submitted by Mr. Sheikh N. Mohammed, the learned counsel appearing on behalf of the petitioner, that the petitioners still enjoy possession over the said land, as there has been no eviction carried out. I've also heard Mrs. Yudas, the learned additional senior government advocate, who submits that in view of the land policy of 2019, the petitioners have now to freshly apply if they want any settlement. She further submits that she has no instruction as to whether the petitioners have in the meantime been evicted from the said land. Taking into account the above, this court is of the opinion that if the petitioner, this court, is of the opinion that the petitioner should be given an opportunity for the purpose of applying in terms with the land policy of 2019. So accordingly, the petitioners herein are given the liberty to apply within 30 days from the date of the incident order before the concerned Deputy Commissioner. It has to be done before before the Deputy Commissioner Hosai. Before the Deputy Commissioner Hosai, in terms with the land policy of 2019. And if the petitioners in the meantime have not been evicted from the lands in question, then the petitioner should not be evicted till such applications are disposed of by the concerned respondent authorities. It is, however, made clear that if the petitioners fail to file the applications within 30 days from today, the respondent authorities shall be at liberty to take such action if not already taken. Such action of eviction if not already.
May I speak, Lordship?
Yes,
Lordship, if you notice on page 29, my Lordship,
the forest where the petitioners are in occupation is the reserve land. However, the record do not show that any notification for the you file an affidavit.
Lordship, we do have the records as well as the notification. However, Lordship, we sought for a legible one, but we will be filing it shortly, Lordship.
When?
In 2 weeks, Lordship.
Yes, Mr. Gogoi. You took an opportunity on 13/10/2023 to file it. I gave you how much?
No.
Today is 8/1.
no, my lord, there is
2 months,
Subruddin,
2.5 months.
there's always an affidavit is there.
Affidavit is filed.
Affidavit also contains a notification, I think.
No, notification does not.
There is there's an affidavit. But this can be brought, my lord, it has escaped my knowledge. It was a very old notification. It was we have trouble in typing it, my lord. So while it grant me some time, I will bring it on record. Otherwise, affidavit has been filed, wherein that fact has been brought on record.
When did you file the affidavit?
Affidavit, my lord. On
No
10,
affidavit.
10, 12, 2020.
Huh?
10, 12,
10/12/23.
2020. I received the 2020.
No. After 13/10/2023.
Oh no, thereafter no.
Then
Affidavit has been filed.
that
It
is
is
why I
earlier.
gave you such a long time.
I just need a week's time.
Okay. This is the matter again on on 19th of January 2024. So in the meantime, the respondents are directed to bring on record such notification, if any, as regards the reservation of the forest wherein the petitioners are in occupation.
Highly obliged.
Plan appears on behalf of the petitioner on call. Yes, government, what's your stand?
My lord, we have no instruction, don't have
No instruction?
no instruction. Now I couldn't file any letter also. May I take my lord, to get the instruction? Deal such a non-payment of this.
Animal husbandry and veterinary department is there somewhere. Their names have been shown. Has it? List the matter again on 22nd of January 2024. This taking into account that the petitioner as well as the counsel for the animal husbandry and veterinary department is not represented. List the matter again is directed to be listed on 22nd of January 2024. It is made clear that if the petitioners are not presented on the next date, the instant petition shall be dismissed for non-contribution. The counsel for the animal husbandry shall also apprise the court as to whether, as regards the entitlement of the petition on the next.
My lord, in this case, I have received the instruction, my lord, that execution case, my lord, has been listed, has been fixed on 18/1/24.
Yes, what is your stand?
My lord, this is the instruction.
Submitted the order.
Huh?
Last occasion, your lordship passed an order.
And what is the AI doing? You
Submitted. So next 18 is the fixed date. Lordship. Come up after 18. Something.
yes, you bring it to
Yes,
the notice
we-
for that. Pursuant to the direction passed by this court on 10/11/2023, this is Utah, the learned additional senior government advocate has placed before the court an instruction issued by the additional district commissioner Karimganj, wherein it has been informed that the office of the circle officer Karimganj had submitted a report related to the aforesaid estate case directly to the office of the solicitor stating that the task mentioned in the petition in the exhibit contain land of rain, Kalibari, government quarter, roadway, etc., which is under the occupation of some private person. And the next date for the state case is on 18/1/2024. So this court fixes the matter again on 5th of February 2024. So the counsel for the petition is directed to submit the court of the learned executing court, that is the court of the civil judge, Junior Division Karimganj, is directed to take appropriate steps in the said execution proceeding. And also submit a report to the registry of this court so that the same can be and submit a report as regards the status of the execution case being titled execution case number 15 oblique 2015, 2005 before the registry of this court, and the registry shall in turn place it along with the record of the next date so fixed. You give a copy of this order. The registry shall also communicate this order to the court of the civil judge. Junior Division number 1, Karimganj. For due compliance.
The petitioner's report is honorable court member, the candidate. They are deciding, sir.
Yes.
These are the petitioner's matter. They are the language person and originally they are from under Corpora matter, and due to erosion matter, they lost their and thereafter they settle matter at Sandia Bottom matter in the present place of reside. The respondent authorities method on 24/7/2017 method, they have been adequate method. Their agricultural land also occupied by the respondent. These petitioners are still now living nearby the area, in that area. They have also applied for settlement before the Deputy Commissioner Dorong. Their representation still pending. And thereafter, my lord, the new land policy, my lord, came, my lord, in the year 2019, my lord.
Yes, revenue.
Revenue.
There has been various directions passed by this court on various occasions. And your earlier predecessor have also stated that he has received the instructions and he would like to file the affidavit in 2019. Why till date no affidavit has been filed? Why?
So that's in the order, but
Then? And there is also a direction that the commissioner and secretary would be called for. And if the instructions are not received by the learned counsel for the revenue department by the next date fixed, this court will consider the personal appearance of the commissioner and secretary.
1 week time may be granted, my lord.
Then?
I'll take instruction. my
File
lord.
your
Take it,
affidavit
my lord.
next week. Having it on 22nd, file your affidavit by 18th.
My lord.
List the matter on 22nd of January to 22nd of January 2024. The Revenue Department of the Government of Assam is granted a final opportunity to file their affidavit
The
by
Deputy Commissioner,
19th of January 2024. It is made clear that if the affidavit, if the revenue authorities fail to file their stand, this court shall pass
my lord,
appropriate.
Deputy Commissioner affidavit is there, my lord.
Not here.
They are not
Yes,
landless,
my
my
lord.
lord.
We have filed, my lord. They are not landless and no allotment, without settlement of my lord. They were illegally residing there and no
No,
proof
no,
of document.
affidavit has been filed by respondent number 2 and 3.
Yes, my lord.
2 and 3 is the deputy commissioner.
My
Yes,
lord,
my lord.
my lord.
I am saying about the commission, the revenue department, because there the stand which have been taken out here is that these people, all these people, yes, they were residing. They are erosion affected people. Then what stand have you taken as regards them? Where will they go?
In the affidavit, my lord, filed by the deputy commissioner, there we have stated that no documents found as a proof of erosion of land and also landless status of the petitioner. my lord. They could not give any kind of document, my lord, before the authority. my lord.
Where?
And to, my lord,
Para?
paragraph 5, my lord, of our affidavit.
But we have to take instruction from the Deputy Commissioner. We have to take instruction from the Deputy Commissioner, my lord, concerned deputy. But
my lord, this I think that they are still strong, my lord. Still strong, and they have also applied for settlement, my lord, before the Torah.
Where? Where your settlement application?
Settlement application. Para 4, my lord. To make a statement.
my lord, if they have any document, my lord, that they are landless person, my lord, or erection affected, my lord, I have taken instruction upon my
But who will issue the certificate, my lord?
Hmm?
These are the uneducated person, my lord. And
You are
to
there,
use
na?
them. Yes, my lord. There are
You are
4.
there. From 2018, you have been there.
Yes, my
They are guide. Then they are no longer uneducated.
These are the
I hope you consider yourself to be
Yes, ma'am.
educated.
cultivator, my lord. Full cultivator.
Then
They are
you want
agricultural
a
land.
particular status now. Where are the applications? You have only submitted an application,
Yes, my lord.
a
One-
representation.
one
Would the
representation-
representation do? No,
one
no, tell
repre-
me. No, Mr. Counsel,
Yes, my lord.
tell me. Whether a representation would do in view of the land the settlement rule?
Kindly case
I've seen it, I've read the entire petition in the meantime, when
Yes.
you were saying.
case
I'm
53.
asking you, you submitted the representation on 24/12/2018.
No, my lord. Yes, my lord.
Yes. That is the representation which have not been considered and for which you have approached this court by filing the instant petition.
Yes.
Now the question arises, can on the basis of a representation settlement be granted to you?
No, my lord. Hereafter,
How?
my lord,
How can it be granted? Tell me.
now, after filing
You
this-
have that book, Assam Land and Revenue Manual?
no, my lord.
Give it to him. Take one. Video.
My lord, a new land policy, my lord.
No,
like
forget about land
2009.
policy. We'll
Yeah,
come to the land policy later on.
Under the new land policy, my lord, we will apply for settlement, my lord.
See this. Come to rule 5 of the settlement rule, not the regulation. You are looking into the regulation. Come to the settlement rule, not so rule.
Regulation. Land policy, my lord.
Settlement rule. Madam Yudas,
My lord.
kindly take the book from him and show him rule 5. He seems to be very new to this type of litigation. Give me that book. Let me find it for you. Yes.
My lord. By written, my lord, as per instruction, my lord, they represented my
As per your instruction, you
Yes,
are to withdraw. Yes, read.
rule. Application for land.
Yeah.
Application for lease of first land shall be in writing and shall be presented to the deputy commissioner or to such other officer as may be empowered by the deputy commissioner under Rule 6. They shall be made in such form as the state government may from time to time.
So, would the representation do?
Yes, my lord.
No.
As per my instruction, my lord, they have represented my lord for settlement, my lord.
Representation would not do. You have to file, everybody has to file an application
Application and representation.
in
is
that
not-
particular format. And then you see rule 6, 7, how it is to be inquired upon. And then the government, it will go to the government and then the settlement will happen.
Yes, as per
This
form
is
number,
not the manner by which you submit a representation, you will get a settlement.
form number 20.
Thing is that, my lord, now the new land policy.
Understood. The land policy also, you have to file an application.
Yes, now I will fight.
Not now. It was all along from 1989, their land policy was also there for the purpose of it. So you file application. This is not, this court, how can the court give you a settlement or direct them to settle the land with you?
Yes, my lord. Now we will find in a
The learned
appropriate-
counsel appearing on behalf of the petitioner submits that he would advise the counsel, advise the petitioner for the purpose of filing the appropriate application in terms with the settlement rules framed under the Assam Land and Revenue Regulation 1886, read with the land policy of 2019. So he therefore submits that he would not like to press the instant writ petition. But he, however, submits that the withdrawal of the instant writ petition should not prejudice the petitioner in such application so far. Taking into account the above, the instant writ petition stands closed on withdrawal. However, the petitioner herein would be at liberty to file individual applications seeking settlement as per the mandate of law and in terms with the land policy of 2009.
Till then, my lord.
What till then? You are not there.
That is
No,
right.
yes, my lord. We are still now
There is
dear
no
my lord.
interim order till now.
Lordship,
There is no
already
interim, my lord.
their statement is that they have been evicted. my lord.
Your
No.
own case is that you have
They
been
have been
evicted.
Thing is that we are still now residing in the area, my lord.
You
Therefore, my
say
lord,
that you have been evicted.
till disposal of my petition, my lord, will not be evicted, my lord.
You are
From-
not
from
there.
which
You
land, my lord?
yourself, it is your statement.
From which land they will not be evicted?
My
Tell
lord,
me.
kindly, my lord, this is a landless person, my lord. Kindly, my lord.
Sorry.
Till 1 month, my lord. 1 month time, my lord.
No, you are not there till now.
No, yes, we are here, my lord. My lord, statement kindly peruse the petition, my lord. Kindly, my lord. We are still now dear, my lord.
Their prayer, my lord, in page 11. Which were evicted and further allowed. Already evicted at the time of filing of the petition.
Evicted our agricultural land, my lord. Agricultural land, my lord.
Counsel, kindly see your petition. Kindly come to paragraph number 11.
Pending disposal.
Para 11.
Para 11, page 8. There stand.
And then what is your prayer? Interim prayer? Pending disposal of your lordship may be direct the respondents to allow the petitioners to reside in the land from which the petitioners were evicted.
And
That is the final relief. And further allow the petitioners to harvest. Yes, yes.
At least 1 month time, my lord. At least, my lord.
From which land?
You file in 10 years. Whenever you file, they will
Now
consider.
we'll apply, my lord, for 1 month, my lord.
For what?
For 1
From
month.
which land?
For applying time, my lord.
You apply. I've given you the advice.
But now, my lord, respondents still now, my lord, coming for eviction, my lord. They are residing here, my lord. Only for 1 month, I
You
am
have
taking,
been
my lord.
already evicted, Mr. Counsel.
Yes, I
Then-
admit, my lord. Statement is there, my lord, in my petition. Only for 1 month, my lord.
Okay.
Kindly, my lord. The landless, my lord, they have no any alternate land, my lord, to move, my lord. Only for 1 month, my lord, I am speaking, my lord.
Next.
35.
Leave, leave, leave.
Yes.
Oh, infrastructure.
Payment. Withdraw. Infractuous. Mr. Ashwama, the learned counsel appearing on behalf of the petitioner submits that the petitioner have already received the entitlement and as such would not like to press the instant writ petition. Accordingly, the instant writ petition therefore stands closed on withdrawal.
36.
Yes, where these matters have been lying all this while.
Regarding matter, the non-reimbursement of medical bills matter of the pensioners matter. Matter in the organization which is represented by the secretary of the pensioners matter, he already expired in the year 2019 November matter. Thereafter, new committee has been formed matter, but I have not communicated that who is the secretary.
Who is appearing for the respondent?
For one, government of Assam, and for 2, 3, 4, and Kanya Rutakat NC.
They have not filed their affidavit
None of the 5 affidavit.
and has their names been shown?
My lord, response 2, 3, 4 not from my lord. Only earlier occasions they have took time matter.
Huh?
One occasions they have took time in the year 2018 itself matter. But
Which orders you are challenging?
my order plan is page 28 and page 30, my lord. Page 28 is resolution, page 30 is a memorandum.
28. Yes, what is this? So the medical reimbursement would be made as per the CGHS list.
They are trying to reimburse the CGS series, but earlier, my lord, since 1995, my lord, we are getting full reimbursement, my lord. Thereafter, in the year 1983, there is the rules, my lord. As per that rules, my lord, we are entitled for reimbursement, my lord. But in the year 2011, my lord, they start to reimburse at the CGS rate, not full.
Who does?
My rule 1983 is stated in my, it is my page number 6, my lord, para 4. I have also copy of that rule, my lord. And their service career, they are receiving full reimbursement. After retirement, they are also getting full reimbursement. But all of a sudden, they're trying to change the service condition after retirement. Till that 1983 rules is not amended. my lord.
There's a writ petition filed earlier.
That's my lord.
What is that?
My lord, get it to
What
my
was the
lord.
direction?
Page number 51, my lord. And 47 also, my lord. In first requisition and the court director to dispose of requisitions on pending before the authority, my lord. That was disposed, but our grievance was not considered, my lord. Second time we have filed the requisitions, which will find page 51. That time court holds that we have challenged the only notification, not the resolution, based on which the notification was issued. On that ground, that petition was closed, my lord.
The matter upon being called, none has appeared on behalf of the respondent number 2, 3, and 4. Madam, what instruction you have in this matter? Because they have done so in view of the government's, Assam government's thing. What is your stand?
My lord, again, my lord, I need some time.
Mrs. Yudas, the learned additional senior government advocates appearing on behalf of the Labor Department of the government of Assam seeks for some accommodation for the purpose of obtaining the instructions to this the matter again on 12th of February 2022-24. In the meantime, the respondents herein are directed to file their affidavit without date by 8th of February 2024. Is made, yeah. However, failing to do so, this court shall dispose of the instant proceedings on the basis of the materials available on it.
Not sure. Not sure.
Happy. Well, in this case, my lord, the respondent number T has filed affidavit in opposition lordship. My lord, again, that we have to file reply lordship. We have also subject application of my lord for copy of the patta granted to the petitioner lord. My lord, that has not been yet been, that has yet not been provided lordship. My lord, it may be listed after due petition or with after we file affidavit. We are waiting for the certified copy of the patta lord.
Yes.
My lord, respondent number T has my lord filed affidavit lord. In reply, lord, the patta granted to the petitioner, my lord, the original is not with the petitioner lordship. That order is my lord with the office lordship. We applied for the certified copy of the patta granted to the petitioner lordship. And initial patta lordship that has not yet been my lord provided lord. That is why we could not examine the type of reply lord. So further time may be granted lord, we file reply lord.
The petitioner herein seeks for an accommodation to file a reply to the affidavit in opposition filed by the respondent number 3. This the matter again on 16th of February 2024. In the meantime, the petitioner shall file the reply.
Obliged.
Yes.
Also the whether the petitioner apply for capital investment subsidy for
Petitioner applied for?
capital investment subsidy, my lord.
Yes, then
For the cold storage, my lord. Your lordship find at page 20, my lord. They applied for extension of the LOI. Now, the National Horticultural Board, my lord, it is as if it's the expansion unit, the new unit. They applied for, my lord, bank loan also, which is sanctioned in the meantime. They, in page 21, my lord, they say that you have to keep this data because it's the expansion unit. They have not issued the LOI.
let's see the orders dated 2/5/2018.
2/5. Yes. That is, my lord, 37. My lord, I to inform you that as per director of department, I replaced the letter of intent system in principal approval effect from 1/4. To facilitate the business have not obtained LOI for doing so, but banks have sanctioned farm road for the executive project. Public notice with offset, promoters with farm loan from bank for their project and they have not opted for LOI. Here, my lord, we have opted for LOI. Not from NHB, but requested to register their proposal online during NHB from so. Only those projects eligible for IPA under the scheme whose farm loan has been sanctioned after 1/4. But our farm loan has been sanctioned, my lord, on 9/3/7. So the new scheme we are not covered. That is my case. And in the affidavit also the same thing has been said, my lord, that LOI has not been issued. LOI, my lord, I am not at fault, man. NHB has only taken it as a action.
Heard Mr. G. N. Sahiwala, the learned senior counsel, appearing on behalf of the none has appeared on behalf of the respondent on call. Taking into account the matter in its entirety, this court fixes the matter on 6th of February 2024 for final.
The respondent has filed their affidavit.
Mm.
It filed their reply. The respondent forest department has filed their affidavit. It
You want to
filed-
file a reply? Affidavit for what?
The petitioner was the settlement holder for a San Mahal for a period of 7 years. The settlement order was 2016 from 1700 cubic
Then
meter.
counsel appearing up seek for accommodation for filing the reply to the affidavit filed with the for 4 weeks time. Not to list the matter of 6. Yes, Mr. Aloy,
Lordship,
the last occasion you were not prepared.
no, Lordship, state was directed to produce the status report with regard to the investigation carried out by the police. State was directed, D. Gogoi was directed. We're a formal party in this case.
Lordship, that 2 meter transferred to CID. Now it is pending before CID matter.
This court has directed placing the status report by the officer in charge of the
Actually,
Jalukbari police station.
We have received instruction from IO of Jalukbari police station. Right now that is, it may be take up after 5 minutes, my lord, because that is in the office, my lord, that they have not sent.
We'll take it up at 4 o'clock.
Yes.
Yes,
Except rupees 46,000, my lord. Remaining part disbursed
46,000 remains.
because non-submission of the documents and the bank account, etc.
But we file out affidavit in reply.
Sorry, 40, not 46, 64. Yes, this is the instruction for.
This is for the purpose of acquisition.
Acquisition of bank.
Where's the award? Is there any award passed?
Yes, that is why, my lord, last occasion, our submission was, my lord, the requiring authority placed the fund with the deputy commissioner.
Hmm.
Then lordship wanted to know whether deputy commissioner has disbursed the amount or not.
No, no,
So that-
understood. No,
Yes,
they were saying
Right.
that the total amount is some 4 crores or something.
yes, 2 crores 71 lakhs.
No, 4 crores 54 lakhs.
Yes.
Out of which only 2 crores 71 lakhs have been paid.
Right.
Now
As
this is the
assessed by
2
the
crores
deputy-
71 lakhs.
Yes, as assessed by the deputy commissioner.
Assessed. Now, what is the award? Award amount?
I think that is the, my lord, total amount, because we can put amount out. No, this is the communication from the requiring authority, my lord.
So as per you, it is not 4 crores.
No,
4 crores was the preliminary. And the final was 2 crores 71 lakhs, of which you have paid already 2 crores 46 lakhs. And
2 crores 71.
45 lakhs you have paid. Remaining is 24 lakhs is the government constituency and cost. And 64,000 you have not been able.
No, PC has not paid because the
Those
award is-
people have not placed. it.
Yes, that is the instruction.
Now the petitioner herein have received how much? They have received the money.
Yes, yes.
Then
And 1,83,000.
what? No, no. You are only how much you have received?
2 crore 71 lakh.
You can't get 2 crore 71 lakh.
We have not said, my lord. We have
They
said
have
only-
not paid you 2
Yeah.
crore 71 lakh. You don't know all these things. You, Mr. Goswami,
My lord,
you kindly produce the list of benefits.
it's the beneficiary.
List
Alright.
of benefits. Then it will make it clear.
My-
Because you are not going to get the help from the petition account.
My-
So I think this will,
Deputy commissioner can copy.
yeah,
Yes.
they will place the list of beneficiaries.
Right.
This will make it clear that
Right.
to whom this amount has been. Pursuant to the order
In
dated
that context, only, my lord-
19/12/2023, Mr. P. Goswami, the learned additional advocate general, Assam, have placed an instruction issued by the District Commissioner Gwalpara to the effect that the final estimate for the implementation of the scheme was rupees 2 crores 71 lakh 37,631. Out of the said amount, the total payable compensation amount was rupees 2 crores 46 lakh 54,200. And the remaining amount of rupees 24 lakh 83,431 was on account of government contingency oblique establishment cost, etc. It has also been mentioned that out of the amount of rupees 2 crores 46 lakh 54,200, an amount of rupees 2 crores 45 lakhs 90,139 have already been released to the beneficiaries. However, an amount of rupees 64,061 is still lying on account of non-submission of the required documents by the beneficiary. The said instruction submitted before this court during the course of the hearing is kept on record and marked with the letter X. List the matter again on 22nd of January 2024 on which date the district commissioner, Kualpara, shall provide to this court, shall place before this court the list of beneficiaries in respect to the amount of rupees 2,46,54,200.
42. Maybe. Lordship, matter pertaining to accuracy of matter pertaining to accuracy of Dear Lordship, respondent number 1 and 3 have been filed affidavit in opposition, Your Lordship. And the amendment in the affidavit, Your Lordship, will find page 32. Your Lordship.
Accuracy for what? Drowning.
Yes, sir.
Oh, is that the case? The drowning case?
Yes.
Yes.
Lordship, will find page
I have
32.
also duly taken note of the police report and close to the petition wherein it seems that and on. In order to be entitled. They were supposed to file an affidavit. Have they filed an
Yes,
affidavit? Okay, then
sanction already.
Huh?
Sanction already accord. Lordship will find at page 32 affidavit filed by the respondent number 1.
affidavit filed by the respondent number 1.
Page 30.
Yes, what does it say?
Lordship, as per amendment made in affidavit, Lordship sanction already accord in respect
Huh?
of the disease. Sanction already accord in respect of the disease.
You have got it?
No, Lordship, but wait for
Where? 8?
32 years.
Meenakshi Das.
Yes.
Date of the date of death, drowning. Here it is Meenakshi Das. Okay, you are getting the money.
No, Lord.
You will get the money now.
Yes.
They have admitted
We
it.
have sanctioned, my lord, now deputy commissioner to discuss the.
Yes, you are paying within 15 days. You have got the money. Here is the report so and so. The concerned head of account is there under which the sanction is accorded is so and so. The sanction is debated. Okay. The instant writ petition has been filed by the petitioner being aggrieved by the inaction on the part of the respondent authorities in not making payment of the ex gratia to which the petitioner was entitled to under the provisions of under the
15, 11, 2004.
entitled to in terms with what? Which scheme?
Lordship,
In terms with the notification dated 16/6/2015 issued by the Government of Assam Revenue and Disaster Management Department. Full stop. This court have also perused the affidavit filed by the respondent number 1, that is the Joint Secretary to the Government of Assam Revenue and Disaster Management Department, wherein the order dated 29/11/2023 have been enclosed. The said order reveals this is done under the other act.
yes, Lordship. Lordship, at page 30, your Lord. Affidavit at page 30. Paragraph number 3. Your Lord.
They have given under the 15/11.
Yes,
You don't want under this.
Lordship. Actually,
They gave it on the public place.
yes. As per due verification,
So?
they are-
You are happy with this? or you want the other one?
No, sir. Yes, sir.
Happy with this? When an order has been enclosed to the effect that an amount of rupees 2 lakh have been sanctioned in favor of the petitioner. In terms with the government notification
That is-
dated 15/11/2014.
Yes, sir.
The petitioner, the learned counsel for the petitioner submits that the petitioner is satisfied with the said sanction of rupees 2 lakh in terms with the notification dated 15/11/2014. And would not insist in terms with the notification dated 16/6/2015. Taking into account Mr. N. Goswami, the learned counsel appearing on behalf of the District Commissioner, Kamrup Metro, submits that as the amount has been duly sanctioned, the said amount would be duly disbursed to the petitioner in the bank details as mentioned in the said sanction order. Taking into account, he submits that some time may be granted to the District Commissioner, Kamrup Metro, to do the needful. Taking into account that the said sanction has been granted as far back as on 29/11/2023, this court disposes of the instant writ petition with a direction to the District Commissioner, Kamrup Metro, to disburse the amount of rupees 2 lakhs to the bank account of the petitioner as mentioned in the order dated 29/11/2000, in a sanction order dated 29/11/2023, within a period of 30 days from the date of submission of the certified copy, if not already disbursed.
Keep your-
Or if we asked for status report, but they said that call for case diary. Actually, we not call for case diary, status report. On that day, my lord, they sent this.
This was given on 15/11.
Yes.
Then we are
La-
today.
Last occasion, some
Origin
other
thing is
PT
a
was
long
appeared, my lord. I was not there. But
No, you are not there. Your names have been
yes,
glaringly
shown, my
shown,
lord.
but
Yes,
then also
yes, yes.
nothing. So what to do?
My lord, give me some other that, my lord, I will bring that status report, my.
Tomorrow, 2 o'clock.
Yes, yes.
Is the matter tomorrow at 2 o'clock? On which day? Full stop. Mr. B.B. Gogoi, the learned counsel appearing on behalf of the petitioner, on behalf of the respondent state, shall apprise this court as regards the present status of the Jalukbari PS case number 1510/2018 and Jalukbari PS case number 1768/2018. Ito kalina la puro ki dito. 10-1. 10-1. BB Gogoi. updated status.
My lord, this writ petition pertains to the writ petition is before your lordship for a notification of election tribunal in BTC area, particularly 27 Nagri Juli constituency. So, my lord, here what we have done is, my lord, during this pendency,
You are supposed to file affidavit.
my lord, we will not file because, my lord, I have information. My lord. Already, my lord, for the whole of BTC, we have taken approval in all stages, judicial department, then state election commission. Now it is in final stage of notification. In next 2 weeks time, principal secretary told me that the notification will be out.
Is the matter again on 2nd of February 2024. On which date Mr. Ardhor, the learned standing counsel of the
Boroland Welfare Department here, my lord.
Boroland,
Party here, my lord. Now it's
the learned additional senior government advocate
my lord.
shall apprise this court as regards the notification as to whether the notification has been issued for the purpose of constitution of the election tribunal
Tribunal in BTC area.
in the BTC.
My lord, keep that.
44.
Yes, Mr. Bhattakur.
Lordship, there is this affidavit has not been filed. Petitioner number lordship now 1090.
Huh?
1090 number of
Then court fee 20. Land counsel appearing on behalf of the petitioner. You have a case?
my case is this, your lordship, that we should be, your lordship, paid as per the 2013 Act. But they have paid us, your lordship, in terms of 1896 Act. Calculation award was passed. And in fact, the government, your lordship, by writing a letter to the BTC authorities, has directed them to prepare the
See, the question of quashing of these proceedings does not arise. Now, if you are entitled to, if they are paying you as per this, I think I delivered one judgment in your case or whose case?
not,
Huh?
not
Yes, I've delivered out there that you are to approach under 3G.
But your lordship, so far as the calculation to be made, your lordship, that is not under 3G because it is not under National Highway Act. They, your lordship, acquired it under 1896 Act, 1894 Act.
So if it is then you have to file it under you have to file a section 18 application.
For your lordship enhancement. But
Yeah.
your lordship, so far as this situation is concerned, whether that act will be applicable or this act will be applicable, that has to
No, that act or this act will be applicable, yes. Yes, this matter came up before me only earlier. That act or this act means that will be that
whether
has
it
to
will
be
be under
that is a thing which has to be decided by the district judge.
whether your lordship 1894 Act will be applicable or sub 13 Act.
You are to file it before the deputy commissioner. Your application. Once you file it before the deputy commissioner, you see, there are two things. Normally, if it is done under the 1894 Act, they have done it.
Sure.
Then the district commissioner will have to decide. The reference has to be made in terms with rule 9, section 19. Reference has to be made to that particular district court.
Sure.
Now, if it is done under 64, so you apply both.
Lordship will kindly come to page 363. This is a letter by the Deputy Secretary to Dr. Assam.
363. Yeah.
That the estimate of the land proposed for the acquisition of the project is prepared as per provision of Act 1894, which has been repealed and replaced by right to fair compensation transfer. An estimate is to be prepared under fluent. There is a specific direction authorities by the state.
No, understood. This will be your evidence.
Lord.
You will get your interest. Interest is very good. If you keep it in your pocket out there, you wouldn't get so much. 9% and 15%. Because this court cannot sit over that, no? Or direct them. Because if I direct the authorities out here today this court will be granting them, giving them a jurisdiction which they don't have as of now. They don't have the power to recall. They don't have the power to revisit the award. The power is only of the appellate authority, whose judgment I have given. I have given a detailed judgment on this aspect. Which
One judgment is there, your lordship, by
no.
your
I have-
lordship judgment, your
I have- Yes. Remember that case. Yes, this one.
Right.
I have to give it to him. In this case, I have duly dealt with that cannot be done. In any case. Ah. We'll take it up on some other day. But
I will go
instead
through
of
that
paying so much of money, now we can close it out there, giving you the liberty to do that. You have a look at it. I will have it on when 11. Suppose it. He'll give you the judgment. It's the matter on 11th. Because you have to do that. See, there is a judgment of the Supreme Court, Sardar Devi, wherein the Supreme Court categorically mentioned that it attains finality. So once it attains finality, it can only, that finality can be touched only by the authorities empowered under the Act. And the authorities out here in these cases would be those. So under such circumstances, will be have to be done by. You take it. Okay.
Okay. 50.
45. This matter has become instructive.
The
Relating
so the
to-
learned counsel appearing on behalf of the SN committee, the learned submits that the petition has become instructed. And according to the petition, that's closed. In time order, if it is.
47.
Yes, Mr. Vishwas,
Yes,
what is
Madam
this
Chair, my
delay?
compensation has not yet been paid, but in spite of the fact that I have been pursuing the matter since the days of acquisition of my land in 1976, there is a correspondence on my your lordship giving them direction. Take the position of the, they have brought that.
Yes, what is your instruction?
Take उत्तर देशाचं record का.
76. Why did you wake up so late?
What happened? We are under assurance that we will get the money. There are so many people. Nobody got the money.
Nobody got the money, so at one point of time it is there. We are in 2020. You filed it in 2021 of an acquisition of 76. How do you expect these authorities to find out?
The gentleman is pursuing the matter. I have annexed all the data, including the chief minister of Assam also.
Pursuing the matter where?
The deputy commissioner and Lord, the that revenue commissioner, all this thing.
Where you have enclosed?
Well, one
Show me.
letter I think I take you lordship first.
Huh?
Annexure 2 kind of see.
Yes.
This is the land acquisition branch method. Case number 29.
Yes.
Then my lord, I take you lordship to my letter dated before the land acquisition officer.
Which
Then
one?
my lord, there is a letter from the authority.
Page 24.
Yes.
Where is it received? Where are the receipts?
They have fixed the amount also, how much I will get. Thereafter it was not paid. Then my lord, I take your lordship, page 25 and 26, my lord. 26 also it is
I
the
think
letter
it
of
is
the
high time you give
under
up all
cited to
this.
the government of Assam.
High time you give up all these things. Don't do this. 76, why are you saying? I think you have approached the right person, the chief minister. He may give it to you. For this vote.
But there is no response from that side.
Then there's no way out. You can get it. Yeah, they would not be able. It's a matter of 3 weeks. In the meantime, Mr. N. Gupta. On the next day, it's a matter again on 19th of February 2020. On the same date, Mr. N. Gupta shall apply to court as to whether the records pertaining to LA case number
29 of 76.
29/76 would be traced out by in the office of the deputy commissioner. 62. Yes.
That is your petitioner society is a registered society, but transportation charges were not paid to the petitioner society since 2008 to till today. And that is 11 lakhs.
Number 48, 62
Oh, this matter.
Sorry, Lord.
Yes.
62 supplementary.
You have given the translated copy.
My lord, so far the clause 1, my lord, I have translated some portion, my lord. Okay, I made the translation that I need some revisit.
Mr. Counsel, you have made a very big mistake. Why haven't you enclosed the entire type copy? Now you see the tender notice.
My lord.
The one you have given me only shown me those things, but if you see the type copy of the tender notice, page
Yes.
10 of your petition, if you
Yes,
see,
it is back.
along with the earlier terms and conditions, PAN card, you see what you have enclosed. What is the meaning out here? The cooperative society, so and so in the name, PAN card in the name of NGOs are to be submitted.
May I take your lordship this, my lord, taxes copy, my lord. This clause 1 is specifically stated, my lord. May I read,
Understood.
my lord.
No. Here you see, kindly see clause 1.
Clause 1, my lord.
The certificate of 100% fishermen issued by the Assistant Corporate Register of Cooperative Society to the Fishermen Cooperative Society, self-help group
My
or
lord.
NGO should be submitted along with the tender application. Now, why will the cooperative society issue in respect of self-help groups?
My lord. That is why, my lord, that is the.
No, then in that regard,
My-
you have to understand the first page of the tender notice.
My lord.
In addition to the previous conditions, the PAN card issued by the Income Tax Department in the name of the cooperative society,
My lord.
oblique, self-help group, oblique, list of fisheries proposed to be sold through and tender oblique NGO.
My lord.
Then
My lord,
the PAN cards of so and so has to be given. That means it is not only to be given to a cooperative society, it can be given to any other society.
my lord.
Then if that is any other thing, why will the assistant cooperative society, either the assistant registered cooperative society can give a certificate?
But before that, my lord, may I take your lordship, my lord, the first two lines, my
Huh?
The public in general is hereby informed that the deed documents enclosed herewith can be submitted in accordance with tender conditions. My lord, tender conditions, my lord. This is one of the tender conditions, my lord. My lord, he ought to have challenge, my lord, because he is not, my lord, eligible to for the tender, my lord.
You can only submit a document which can be issued.
My lord.
You can't submit a document which cannot be issued.
Because they are not
Now
fishermen.
you see, no, kindly see Rule 12 of the fishery rule.
My lord.
It permits whom to be settled.
Well-
It categorically says about cooperative societies, self-help groups, NGOs and everything.
Everything,
So
my lord.
under such circumstances, if these people can give out there, and they have duly invited the tenders for everybody out there,
Right.
not only restricted out there to cooperative societies, then where is the question of a certificate of 100% fishermen to be given by the cooperative society?
Thing is that, my lord, because the private respondent, my lord, they are not, my lord, 100% fishermen, my lord. They are banana growers, my lord. That is why creates problem, my lord. I am fisherman. I am consisting of 100% fishermen, my lord. And accordingly, we
They also have a 100% fisherman certificate.
But my lord, they are only for banana growers, not for fishery purpose.
What?
Their certificate not issued by the, my lord, issued by the agriculture department, but not submitted by the, my lord, ARCS or, my lord, other
They got the certificate from DFDO.
Yes, sir, lord.
Yeah.
That is in my affidavit, sir.
They have given it from the
100%
DFDO.
But my lord, when the tender condition says, my lord, you need to submit that kind of, my lord, certificate, my lord, you ought to have challenged this, my lord, tender condition, my lord.
That certificate from the ACRS, why will the assistant register cooperative society give a certificate to a self-help group if it is not a society? Tell me, what business do they have? They can obtain that, and taking into account now, therefore, the judgment of AFCON comes in. You see why I was about to dictate this judgment. Then, therefore, the question earlier, if it was only limited to cooperative societies, then AFCONs doesn't come in. But if they have invited many other people, and for that they have asked for the certificate of 100% from the ACRS, then the authority, being the authority, knows what is to be done. Then I can't touch it. That is AFCON.
But, my lord, when the tender condition specifically stated, my lord, rightly or wrongly, my lord,
Tender condition also stipulates that
My
it
lord.
can be given to NGOs,
and
to the self-help groups.
But-
But the self-help groups and the NGOs, tell me, can they get a certificate from the Eastern Register of Cooperative? Tell me.
they cannot, my lord.
But
That is why, my lord, the tender condition number 1 is, my lord, it is not valid, my lord.
so that is why the authority knows.
My lord.
If the authority accepts a particular document, then they know, yes, we meant this. And this court is not going to sit over it.
That is why, madam, may I submit one thing, my lord? Yes, my lord, the tender condition, I'm not praying that, my lord, the tender may be submitted, settled in favor of me, my lord. May I submit one thing, my lord?
That was to you when even otherwise also you were not going to get it. You were
My
number
lord.
5.
That is why may I submit to one thing, my lord. When the tender condition number 1 is effective, my lord, that the government, my lord, for first tender, my lord, all of us will, my lord,
Are you
participate.
challenging the tender condition?
My lord,
Are you challenging the tender condition?
it is not required because my lord, this is in favor of me, my lord. I am challenging his, my lord.
No. That is why.
My lord.
Anyway,
Because, my lord, this will help me, my lord. That is why I am not challenging, my lord. This certificate I am possessing, my lord. When there is a tender condition, my lord,
I'll take it up on Thursday. Today is very tight for the disposing. I'll dispose it in the court.
Fine.
This is not a such a matter for. Please the matter again on Thursday. The matter having been heard at length. uh, And this is the matter on Thursday for Thursday morning, 11 for final disposal at the top of the list.
Keep your breath. Hello.
Item 48 for the
Yes,
The petitioner society is a registered society, but transportation charges were not paid to the petitioner since 2008, 2008, and that is 11 lakhs 51,008. But this similar case has been already been disposed of by your lordship.
who is appealing for response number 3?
I'm a paying.
Huh?
I'm a paying.
You said that you have filed an affidavit. That affidavit could not be placed out in the CS system.
They have not filed it.
It is called-
Huh?
it is submitted by the advocate petitioner law.
What is this case? Well, This is for non-payment of dues. Non-payment.
Not paid.
Huh?
For the transportation charges.
What?
This was not paid.
Transportation charges is. This is what I have done it. Oh yes. Pertains to which year? 2015. Yes. Why? You have to pick. And you have mentioned that there is an affidavit filed.
That was mentioned by the advocate petitioner law. That is submitted by the advocate petitioner law.
You have not filed. What is your stand?
No,
Huh?
no impact.
No stand.
No impact.
No instruction. Okay, you do one thing. Get your instructions. It's a 2015 matter. 8 years have gone by. This is the matter again on 6th of February 2024, on which date Mr. N. Gustami shall obtain the instruction as regards the petitioner's entitlement. I'm not picking others because rule has been issued. It will come up for hearing. So let it come up for orders. Yes, what is this?
Online
Oh, yes, that matter.
We have filed our affidavit. Lordship.
The file.
Yes.
Then what to do now?
I have been requesting for appeal for the NIA.
This matter pertains to what?
CPI.
Pertains to Lordship, the investigation which.
Oh, that one.
Yes.
No, what has happened? What did the Supreme Court do?
That was state Lordship. State Lordship.
Judgment has been stayed.
Yes.
Then what happened? What is the effect of a judgment being stayed?
Already Lordship, as because the constitutional validity of CPI has been challenged, and that matter has already been discussed.
Huh?
Discussed before this honorable court in division bench Lordship. So state by the Supreme Court, therefore it has no effect Lordship. It has no effect Lordship.
Judgment has been stayed.
State.
Then what to mean? As of now, the CBI has the jurisdiction.
Yes, CBI is investigating.
You have that order.
Not here. I don't have the certified copy, but I have obtained a photocopy of the judge.
This is the first order.
Yes, that is the only order. Thereafter, the matter was never listed.
It has not been disposed of.
With the L.S. Chaudhary or
I think has the leave been granted?
It is not yet granted. I think. That is the
Leave. I
only
think
order.
leave must have been granted in this matter. If I remember correct. It is still, is it, or is it in the still in the stage of a special leave to appeal? Anyway, the Learned Counsel appearing on behalf of the CBI had submitted that the affidavit in opposition have been duly filed and also the cost of rupees 10,000 have been duly deposited. This court directs the registry to disperse the said amount of rupees 10,000 to deposited as a cost to the Legal Services Authority, to the District Legal Services Authority, Kamrup. Mr. M. Halloy, the Learned Counsel for the CBI, has also further submitted that the matter as to whether the CBI would have the jurisdiction is still pending before the Supreme Court in special leave to appeal, bracket civil, CC 20006/2013. Taking into account the above, this court adjourns the matter, adjourns the instant petition, sine die, till sine die, till the disposal of the special leave to appeal, bracket civil, CC number so and by the apex court. The parties shall be at liberty to mention after the disposal of the said proceeding before the Supreme Court.
In this matter, may I pray for some more time, Lord, to apply the honor?
Oh, this one.
Yes, Lord.
What happened?
Lordship, I have
Lordship, one instruction, Lordship, that is Lordship, Paltan Bazar Hak Pasari, Lordship, that is different,
Hmm.
Lordship. So may I prefer, Lordship, 4 weeks? I may be granted, Lordship. 4 weeks time may be granted, but to comply.
Understood, but madam, it doesn't look nice for a 2016 contempt to be
Lordship.
pending.
But
If a writ
Lordship,
petition is pending from 2016,
doing
people look,
it-
but what about contempt?
last Lordship, 4 years, Lordship, petitioner is not present, Lordship, that's why Lordship, it is,
Petitioner is not represented.
yes, Lordship. Lord, that's why the matter is also not listed, but
They must have also lost hope.
Dear Lordship, on land is allotted, Lordship, but that was not suitable, Lordship. That's why, Lordship, on the last occasion, again, Lordship, matter is remanded to the Deputy Commissioner.
You get your instructions, we finish it off. None appears on behalf of the petitioner on call. Mrs. D. D. Borman appearing on behalf of the learned additional senior government advocate seeks for an accommodation to obtain the instructions as sought for by the order dated as sought for by discord by the order dated 22/9/2023. List the matter again on 19th of February 2024 for further instruction update.
Of like,
Yes, what is this?
According to order of the Honorable Court, Expert Committee has submitted the report. It has engaged the geology for movement of the monitor the movement of the independent. As geologist has 3 days ago has submitted the report to us. We required to submit the report by your filing an affidavit. It
Huh?
and take 8 days time to file submit the report.
Mr.
Yes, sir.
And so appearing on behalf of the NRL
My lord.
submits seek for a period of 10 days for the purpose of filing the report by way of an affidavit. Let's the matter again on 21st of February
Can
2024.
it be earlier, madam?
Why?
Some elephant movement has been, my lord.
For 11 movement.
Elephant movement, madam, obstructed by a wall constructed by NRL. The NGT had taken note of that. A petition was filed before the NGT by one concerned person. NGT gave some directions to demolish the wall. They go for review petition to dismiss. They prefer SLP, which was also dismissed. Now, that's with a separate, totally separate cause of action. They have created and they have come and they have not, my lord, they have obtained status quo, my lord. And demolition was called the very small part of the wall, my lord.
24th of January.
Actual fact
24th January. Actual fact is that, actual that is
has
it, my lord.
not been, actual fact has not been placed by my.
Okay,
Anyway,
no problem.
I may allow
You
time.
asked for 10 days, I give you
My
10 days,
lord.
20 days.
Always, my lord.
Hmm.
Lordship, in this matter, we will file an IA for paper application in order to serve.
I come.
No,
No.
Lordship, we are not. We have not filed it yet, but Lordship.
You want to file?
Yes. Lordship, we have already
It's the
emailed.
matter after 2 weeks. In the meantime, the petitioner is at liberty to file an application for seeking substitute to serve.
Lordship, I am representing respondent number 5, madam.
Oh, is it?
Yes.
Matter ends.
No,
Service is complete.
respond number 8 was, notice to respond number 8 was.
Respond number 8 or 5?
8. 8 is right.
9. Okay, file it. Who is 9? Oh, this one. I remember. The husband, wife.
The daughter-in-law, the wife of the
Wife doesn't, the husband doesn't know where the wife is.
petitioner's daughter-in-law, and she is married in with another person, and
This is for quashing.
No, Lord. This is here. They are not happy with the investigation carried out by the company. Therefore, the seeking a directive of this court to over the case.
About response number 9. So it's giving 2 weeks time for the purpose of filing appropriate application for effecting substitute to service upon the response number 9.
But, in this case, the case after land council, Mr. A. Sattar appeared. But some personal reason is out of station. Can it be taken up?
Oh, that matter.
Yes, that matter.
Then
We have filed our affidavit in response to the affidavit filed by the state,
Hmm.
but it would be argued by him. That is why I pay for an.
you started the argument. Then Sattar started.
No, he
Then
will
they
do
was
it.
done by another one. Now you come back to you. Now you wanted Sattar to do it.
No, no, he is, I appeared initially, then,
You started.
yes, I started.
Then
Then Milord,
Mr. Sattar came that I should not do the matter because this matter was done by Mr. Samu. Then I insisted
no.
that I am not going to grant an adjournment, so Mr. Sattar did. Then when Mr. Sattar was doing the matter, after one day, Mr. Sattar and you were both vanished. And then the matter again came to me. Now you want that no, Mr. Sattar. Isn't it? See the records, I remember.
Milord, if to accommodate this for the last time, Milord, if it next day, Milord, whoever is available will argue it. But this Lordship will take it up for this. We have filed as per the instruction. of the
See,
court.
last order. Learned counsel appearing for the petitioner. Seeks for an accommodation on account of the ailment of both the counsel who had addressed this
Yes,
court
I-
earlier.
I was still I am sick, Milord.
Then you are still sick.
Sick, I'm having some problem in the voice.
This court should not be troubling you. So, anyway, list the matter again on when both of you will be well, fit and fine. When?
Date, Milord,
Okay, we'll have it in the month of
after Bihu, Milord.
August. August.
After Bihu.
Let's have it in the summers. Winters are very difficult. Winters are dark and grey. We'll have it in the year. Oh, we should issue rule. Rule has been issued. Is there any stay? No stay. No.
One stay is there, Milord, for in one petition there is a stay.
What stay?
In Milord, in requisition 2639/2014, there is a stay order passed by.
2639 of 2014. What is that? No, there is no stay after 2018. There is no stay after 2018.
Order dated 30 May 2014, Milord.
Understood. 13/5. 35 2014.
14, yes.
Then what happened? Interim 30/11/2018 says interim order shall continue till the next date of listing. Then on 18/1/2019, nothing is there. No stay. 11/2/2019, no interim order. 24/9/2014, no.
Milord, see, even after that interim order, we were evicted. That is why, Milord, we filed another petition, that is 2704, and that contempt of it.
Where?
There, my lord.
2904, 2704.
2704 and a
There is
contract.
also no stay.
No, sir.
We can have it in the summer.
My lord will take it up
August.
after review, my lord.
Find a
towards
good
the
date.
End of January,
What?
end of.
No, no. These are matters not to be taken up so soon. I tell you now, then we don't have those problems. There is no interlocutory error. You are not interested. Now the deputy commissioner has accepted that there was a mistake in
Lord-
issuing that, and as such he has filed a detailed
Yes,
affidavit and bringing it.
Initially, Lordship, that affidavit, Lordship,
I remember. No, this matter doesn't call for so urgent. It in the 13th of August.
Lordship will take it up at least in the first week of February.
What?
First week of February.
No. At the request of the learned counsel for the petitioner who seeks for an accommodation, and this court having perused the matter and its entirety does not find that there is any urgency in the matter, to list the matter again on 13th of March 2020.
much.
They've taken as per the service. On the Summary number 226.
Uh,
Pending counsel, I appear court in the house list. There to appear. Now status quo order is still.
What is this matter about?
This is during the pendency of the contract, my lord, for regard hiring of vehicles, they have issued another NIT without termination of the contract with the petitioner. That also without giving any notice. Totally in violation of the clause of the
Why is it? The service is complete.
service, my lord, we have taken justice service, we have filed an affidavit on 6/24. Does not come on court. That's taken.
List the matter again on, we fixed it again on, we have filed the justice service. Huh?
On 6/24.
List the matter again on 24th of January 2024. The interim order passed earlier. List the matter on 24th. Yeah. The interim order passed earlier shall continue till the next week.